They've got the instruction, their signature has to be there. Item number 25 in the fixed month, which the candidate upgrade.
Item number
25 in the fixed matter. 1178 is there in that note.
yes.
Kindly makes it. Kindly upgrade.
It will be taken up serially. Yes.
27. It was supposed to
Extension of interim order till August end of August.
Yes. Extension of interim order. Please hand over the slip.
May I have my notes kindly to mention an extremely urgent civil revision application. Here, the decree has been executed, decree holder has executed it. After his demise, again, it was taken over by some third party. Now, in the meantime, next person, an application is taken out for repossession of the entire, and that by also not the decree holder who has died, and non-parties.
Indicate the urgency. Hand over the slip.
My lord is there. If your lordship can take up this Friday, police help.
Please hand over the slip. Yes.
On the 10th, your lordship can take up before that.
May I have your lordship?
Yes.
Date, my lord. Can I?
Upgradation. Please hand over the slip mentioning the urgency.
May I? My lord, can I get a date for this?
Upgradation.
Can I get a date for this Friday?
Please hand over the slip. I will consider. I will fix the date.
May I have your lordship's kind leave?
Upgradation. Hand over the slip.
My lord, may I have your lordship's kind leave? My lord, orders.
Please wait. Upgradation. Please hand over the slip mentioning the urgency. Please hand over the slip, Mr. Shah, mentioning the urgency.
Upgradation, earlier the matter was fixed under the as fixed mode.
Please indicate.
May I point to mention the item 39, 40 and 41. I was the void. 1021 not
39, 40, 41 of the supplementary list.
Supplementary 39, 40 and 41.
Yes.
Saying for 3 p.m. because I am the Y 50,000 money not.
How this is difficult because Mr. Shao, it's difficult. On one hand, you are paying for upgradation of matters from the monthly list. Other hand, you are saying fixation. So you decide amongst yourselves how I will proceed. If you say I will proceed serially, I do not have any difficulty. I do not have any difficulty. I can proceed serially. Please make a choice. Tell it to me. I can proceed serially. I will proceed serially. Once you say yes, monthly list matters have to be upgraded. It's very difficult. I know my limitations. I cannot move that fast. That's the difficulty. If you yes, I can proceed serially.
May I, my lord, have your lordship?
Sir, Matt, in the last 5 years, he has complained 2 years back. Project they praying for time.
Hand over the slip.
May I have your lordship's kind leave, my lord? There's a lordship's kind leave, my lord. There's a custody battle. Lordship has heard the matter. There's a separate proceeding arising out of the same proceeding. We filed an order 7 rule 10 because the child
You want upgradation?
upgradation.
Please mention the urgency. Hand over the slip.
My lord, I appear on matter, my lord. My name is not recorded. Yeah.
To mention the
Your lordship.
correction.
Milord, I owe Milord an apology to your lordship. Milord, on 5th of August, Milord, the matter was called on. Milord, I was engaged, Milord, in the DNS allowance matter in Milord Supreme Court. Milord, I was not present before your lordship. Milord, the matter was adjourned, and Milord, following the usual practice, Milord, the matter is no more there in the list. Now, Milord, I am being castigated like anything. Milord, may this
Banerjee is difficult because
Milord, 29th August, Milord, is the next date. Milord, this is from an amendment.
Banerjee is difficult. If same matters are to be called on, other matters can see. Some are saying from the supplementary also they want upgradation
I
fixed.
save my face only by inclusion in the list.
It will be listed. Please hand over the
Your lordship.
Milord, there is
Returnable motion, my lord.
returnable motions. It was hard. Hard ones.
I want.
Please mention after the vacation. It's
I
difficult.
included in the monthly list, my lord.
Please mention after the vacation.
Your
There
lordship.
is a custody matter. Milord, the revisional application is from Milord an interim visitation order in court premises. Milord has changed the order for the time being. Milord directing us, Milord, to meet the child, Milord, in Joy Krishna Library once a week.
Yes.
Now, Milord, the puja is Milord forthcoming. Milord, I want Milord to have my child at least for 2 days during this puja. Milord, may
For
this
that,
matter.
Mr. Banerjee, you have to file an application.
Milord, I will
before
take
the
out an application and mention.
Not here. Before the law net trial,
The
yes, because
sixth, my lord is now in session over the matter. Milord, the revisional application is not disposed of as an interim management and the matter.
revision application is against an order, Mr. Banerjee.
Correct.
If you want a fresh you
My
can-
lord was of the view, my lord, I moved the matter. My lord was of the view that my lord will consider looking at the development. Now, my lord, what is happening there, my lord, once in a week, my lord, we need to meet the child. That's not my lord taking place twice or at the best, my lord, thrice in a month. My lord, the mother is my lord coming with the child and showing some my lord lame excuses, is not bringing the child. My lord, 2 days during the
Wait,
puja.
hand over the slip.
I'm so
Lordship.
grateful.
Eviction of a
What
trust.
do you want? Upgradation.
Lordship, it's for inclusion. I've been mentioning since
Inclusion under what heading?
motion. New
Motion.
Yes. I've been mentioning since July. This matter is not.
It was not taken up once.
No.
Hand over the slip.
Your Lordship,
Please hand over the slip.
Your Lordship, I'm mentioning for expeditious.
What
Expeditious
upgradation?
Yes.
Hand over the slip.
It has been there since 2024 in the list, but it has not been called upon yet.
From?
Since 2024. And
So this is a custody matter of a visitation was going on in the presence of
What do you want? Upgradation.
time fixing, Your Lordship, next week. And
Upgradation, please hand over the slip mentioned in the article.
Lordship, I'm also.
Your Lordship, kind leave to file your recalling application without
For that, leave is not necessary. You can file.
Your Lordship, I'm also mentioning for restoration of a revisional application which was
Hand over the
dismissed from
slip.
report.
May I be permitted to mention what extension of
Lordship,
Please hand over the slip extension.
May I have your lordship's leave to mention, my lord, in spite of your lordship's own order, my lord, that your lordship directed me to produce the evidences. But I am trying to produce the evidences, everything is ready. But still then, my lord, the court below is proceeding expeditiously. I am showing your lordship's order there, but they are not caring. My lord, only, my lord, I will be requesting your lordship to pass an interim order. And lord,
Hand over the
my
slip.
item number 328, my lord.
Hand over the slip.
this matter, Lordship, for inclusion in the list.
Under what heading?
And the motion list.
Lordship, this is a new motion.
Hand over the slip.
Your rights, Lordship, I
Hand over the slip.
Your lordship's leave of mention, your lordship. This is 26, your lordship, a revision plan.
Extension.
So inclusion in the list, your lordship. May kindly.
You have said 1026.
1026 in the monthly list, your lordship.
Yes, yes.
Yes, upgrade.
You want upgradation?
Yes.
Hand over the slip.
Lordship, may I permit you to
Inclusion into the list, my lord, under the heading of motion, my lord.
It's not appearing.
No, my lord.
It was not taken up once.
No, my lord.
Hand over the slip.
My lord, may I be permitted to mention a matter because both the matters are appearing in the monthly list, so I want an upgradation.
Lord, this is for inclusion, my lord.
Under what heading?
Not contested application.
No, please.
Lordship, in the extreme urgency, I have mentioned the matter item number 298. I am the opposite party, my lord. The father is deprived from the visitation of the child
Opposite party,
because the your lordship.
there is no interim order.
No, they refused on the citing that the pendency of the Aniruddha Chatterjee is appearing on behalf of the petitioner, my lord. Last occasion, he requested for mediation, but the mediation failed. I have deprived from.
Hand over the slip. Yes.
One motion and one expeditious disposal.
That is also at the motion stage. Why are you making two categories? Expeditious hearing is not motion. So,
Lordship's leave to mention.
under what heading? Under what heading, sir? Yes.
May I permit you to
Lordship,
mention, Lordship,
My lord, may I-
Lordship for inclusion, restoration application for inclusion in the.
Hand over the slip.
Mentioning one for inclusion in the list under the heading new motion.
At the heading,
New motion.
motion.
New motion. Yes.
It was not taken up once. When you have filed?
2025.
July 2025.
July 2025, it was not listed. Please give me the date. There is no matter which has not been listed. From February, both, na? From 17th of February. None of the matters, you cannot say that you have mentioned the date, it was not been listed. No, madam, yes.
Lordship, listed motion never appeared, my lord.
When did you file?
My lord, it is 2024.
2024.
My lord, the next date in the trial court is fixed on.
Hand over the slip. Hand over the slip.
May I be permitted to mention for inclusion, this matter was made to go out of list pendency of the Supreme Court matter regarding HON'BLE and all that. Matter was,
Made out of list.
yes, so with liberty to mention since the pendency.
Some orders were passed directed to serve.
No. Your Lordship, both sides appeared, the matter was heard, but due to the issue involved that was pending before.
What was the order passed? What is the last order passed?
After
Please
that,
give me the slip.
after order, annex, your Lordship.
Last order चाहिए दर्शक.
Yes, so interim order was extended.
Interim order was made till disposal of the civil revisional application.
Yes, yes.
Now, Your Lordship, the Supreme Court has delivered the judgment. Your Lordship.
Is it so?
Yes, on 13th of August.
Yes. At a new. Yes.
Inclusion of the list. Inclusion of.
Under what heading?
My lord, may I be permitted to mention a matter inclusion in list assigned matter. My lord, last order is 21/2022 order passed that
Assigned matter.
assigned matter. Exchange the affidavit of opposition and reply. Exchange both the party.
Under what the.
My lord, this application was made challenging the report. So I want, my lord, this matter to be fixed on Monday at 3 p.m. My lord. But the urgency is, my lord, since this application is pending, the section 11 cannot be taken.
Yes.
My lord, kindly fix it at 3 p.m.
For upgrade.
I'm at your choice, sir. My lord, it's difficult for the court to function. You are choosing the date and as well as the time.
Any day, my lord, next week.
Something, please leave something for the court. to decide.
Next week, my
Please
lord.
leave something for the court.
Extension of interim order.
Yes, please hand over the slip.
Permit to mention for upgradation, madam.
Hand over the slip, madam. I have said, please mention the urgency and
My lord,
hand over the slip.
may I
All of you mention. I cannot call the list.
may I leave to mention my lord item number 1413 of your lordship list.
If you want upgradation, please hand over
I
the
have
slip.
given but my lord,
Then-
this matter was once moved by the petitioner, but they have sought adjournment.
All right, please hand over the slip. Yes.
Mention on the new motion
New motion. When it was filed?
was filed in 2024.
2024. How many orders were passed in that civil division application? No order has been passed. Hand over the slip.
I am praying for inclusion as motion.
Hand over the slip.
My lord, may I be permitted to mention a matter? The matter is in
What do you want?
I want upgradation from the
Hand over the slip. Yes.
My lord, leave to file a recalling application of your lordship's order, my lord, dated yesterday. Lord, the order is not yet served, lord, uploaded on the server. Lord, if your lordship kindly, lord,
What
comes
recall?
to
What
the-
has been done?
Lord, expeditious hearing has been allowed by your lordship, lord. Lord, I
Take
was,
out an application, Mr.
lord,
Paul.
that's exactly what I'm doing.
Why?
Lord, I
Why?
want a leave, lord, because till now, lord, the order is not yet uploaded in the
Give me the number. Take any note.
My lord.
Yes.
My lord.
Not only I'm taking out an application, it already grants me leave,
Any leave is necessary.
else they won't allow me to file.
Please wait. Let me check up.
Wait.
Yes.
May I be allowed
My lord,
to-
may I have your lordship's
Number.
May I be allowed to mention what matter was upgradation, which is the motion matter.
Hand over the slip. Yes.
Lord, may I have your lordship's kind leave, Miller, to mention a matter?
Hand over the slip.
Lordship, may I be permitted to mention one matter? I have earlier mentioned this. We have filed this application in the month of June. This was taken up once in the month of July. 10th July, your lordship has passed an order to serve this application on the caveator. We have this.
Then, madam, you are saying it was not taken up.
I apologize. Your lordship, may I be permitted to mention restoration application?
And-
May I hand
hand
over
over
the
the slip.
Mention this is the fourth time I'm mentioning.
Great.
This is a matter where I have left the court matter due to an emergency matter. The matter has been.
Hand over the slip.
Kindly take it up.
Yes.
May I have your lordship's kind leave, Miller, to mention a matter, Miller, assailing, Miller, two number of orders, Miller, prefer this revision application, Miller, one, Miller, while, Miller, our prayer for accepting the additional written statement was turned down, Miller, and, Miller, examination of PW1 was turned down, Miller. Now, Miller, these matter was, Miller, heard by your lordship, Miller.
What do you want?
Miller, I want, Miller, upgradation, Miller, because, Miller, next day before the learned trial court is on 27.
Please hand over the slip mentioning the urgency. Call the list.
Wait. I'm so grateful.
Item number 1.
Yes.
My lord, this matter, Mr. Parthaprotim Rai is appealing for the petitioner, my lord.
I'm for the opposite party.
My lord, the issue, my lord, involved in this matter, my lord, whether the order issued, my lord, applicable or, my lord, it is amenable.
Why under to be mentioned?
My lord, on the last occasion, my lord, your lord, my lord, Mr. Roy, my lord, mentioned that one judgment is to be, my lord, shown by Mr. Roy, my lord, of Justice Shubhra.
Partition. Where is it?
Possibly.
Where is Mr. Rai?
My lord, he's coming, my lord. My lord, can you pass it over, my lord?
Pass over next.
Item number 2. Sorry, item number 3.
Item number,
Wait, please, your lordship.
Item number 3 and 4.
for all the reasons as aforesaid, this court is inclined to interfere with the order impugned. Accordingly, the order Yes, call the next matter. Yes, who is appearing? Then finding.
Item number 5.
Who is appearing in item number 5?
For the opposite party.
Who is for the petitioner?
Your lordship, I'm asking for a password for 5 minutes. Mr.
Why?
Patu Putin is coming here.
This is Mr. Roy is busy lawyer. Yes, you start. Please start.
Your lordship, I'm not going to 5 years last.
Yes, sir. What is this matter about?
Your lordship, kindly pass it over for 5 minutes. Your lordship,
Sir.
only 5 minutes. He will come on. He's on his way. Wait, your lordship.
Item 5 to mother.
Hey, item number 5.
Item number 5.
Mr. Rai, you have to ask your jurors to start even the matters. All matters cannot be passed over, Mr. Rai. Yes. Mr. Rai, where is the order passed by this honorable court directing?
Probably section 5 allowed by the trial court. It appears.
That was the submission made on the earlier occasion.
This is the order which was passed under section 5.
Purposely, Mr. Rai, I have recorded that submission.
I also been informed of unless until the order is there, I cannot say. Then my lord, it was this.
No. Order of this honorable court. It was said. There was an order of. Please go through the order. Please look at the order of 18th of August. দেখানো না কে?
Okay.
That was the submission made. Yes, what is this matter?
If your lordship can turn to 78, page 78.
Page. What is the impugned order?
Impugned order was rejecting an application under section 5 of the Limitation Act under section 7, filed along with section 7.2. Section 5 allowed.
Cannot be also allowed.
precisely my that here only I draw a lot of two places
You are the defendant.
on the defendant. Can I turn to page 16?
1/6.
The plaint.
Yes.
Paragraph 4, subpara C.
Yes. Yes.
Now, my lord, can you turn to my application? Application term.
Page.
If you also can turn to page 151, which was filed, that is at page 78.
Page 78. Yes.
You'll also find 7-1 was filed within the period of there is no dispute about the same.
7/1 within the period of limitation.
There is no dispute about the same. Now, my case is
What is the
that
dispute in 7/2?
7 is dispute, not the area. I have made payment, no receipt was granted to me in just 2 months.
No receipt was granted to you.
To me.
Yes.
For 2 months. That is why I intend to file an application to allow me to deposit that amount. That is beyond the period of limitation. So even if that is why I precisely wanted to draw a lot of attention. See, in the plain 6 months advance rent.
Yes.
So therefore, my lord, even if my lord, it can be adjusted or not, because it is on the plain's case is the advancement.
No, 6 months adjust the monthly rent will be 3899 and the defendant shall pay 6 months rent as adjustable advance.
Yes.
So you will have to pay 6 months in advance.
That I have paid.
No.
Subject to action, my lord, if you logically consider once.
Monthly rent is 3899, but you have to pay 6 months at a time.
Yes.
That will be adjusted.
No.
Then you will have to pay for the 7th month.
No, each month. That is why my lord can turn to pay paragraph 4.
Monthly rent is 3899 per month, and the defendant shall pay.
As good as security deposit will be adjustable. 6 months, this is the amount which is given subject to action. That pertinent to mention the defendant was deducted tenant by virtue of an agreement entered into between the plaintiff and the.
So at the time of entering into this agreement, you are directed to pay 6 months in advance.
In advance. And after that,
that will be adjusted. So this was in 2002.
Yes. That amount is kept. It is not with that I have to pay this month. After 6 months, I have to pay another 6 months. This is not the case. This is as good as.
So you wanted this amount to be adjusted.
Yes.
Now, Mr. Rai, even if you want this amount to be adjusted, so according to you, it's a dispute. So you have paid in advance, so you are entitled to adjustment. So it's a dispute under section 7(2). So you have to file. Mr. Rai, there are two things. You may not be required to deposit the amount, that's one thing. But application has to be filed within time. Application has to be filed within time.
Yes, and
whether you are required to deposit this amount or not, that's a different aspect altogether. If you are saying that for 2 months of rent, you can say yes, 6 months is lying in your deposit, so nothing is admittedly due from me. I need not be required to called upon to deposit that 2 months of rent along with the application. Application has to be filed.
7(2), if you logically consider when there is admitted area rents and dispute relationship dispute.
No, not yes. There is a, if you are disputing the amount of rent payable.
No, I'm not disputing.
No, not the rate. The amount payable. That's the dispute. According to you, your case is that for 2 months you have
I have already paid in cash.
You have
This
already
is not
paid, but you do not have the receipt.
Even if
without going into those controversies, you wanted that this dispute, since you have paid the 6 months in advance, let that be adjusted, yes or no. So for that, you wanted a 7(2) to be filed. That's a dispute.
That is a dispute.
But when that application is to be filed, that has to be filed within 1 month.
If there is admitted area, what can you call the language?
Mr. Rai, you are saying otherwise the question of adjustment will not arise.
Yes.
Show me your application.
Yes.
You want adjustment of that.
That adjustment was not paid.
For the first time, this case is being made.
That adjustment was not paid before the court.
Mr. First, second is, even then, even if accepting that you have paid, application you have to file for raising a dispute that has to be within that time. You may not be required to deposit any amount if there is no admitted due. But for adjudication of that dispute, you have to file that application.
The dispute regarding the.
It's well settled, Mr. Rai.
I'm not on section 5. On the very beginning, I have submitted to your lordship section 5. Whether, my lord, if there is a dispute regarding the admitted
Not
dues.
come at any point of time.
No, whether the admitted dues or not.
No, admitted dues, I accept. No, it was rejected on that ground.
Delay.
So,
Malkali considers
even if I accept that you are not required to deposit the admitted amount, delay on that ground, it has to go.
That is the only thing, my lord. So, for the delay, this order is not been challenged, section 5.
Which order?
Section 5 allowing application has not been challenged by the parties.
No, this was allowed.
Section 5 was allowed, it is directed to be heard. Now, this order has not been challenged. Be as it may, I am not on that also. Whether, my lord, in absence of any admitted dues and in absence of any allotted relationship, I want to say that, yes, the amount is lying with you, you can pray for adjustment. Whether for that, my application will come under the provision of section 7.2 or not.
On what ground it was rejected?
Delay. Whether that can be considered after passing of this order. Not be challenged. Even wrong order. I am on the basis if it is a wrong order. My lord, you will find the second paragraph. By filing, the said applicant given name has stated that they used to pay rent regularly to the plaintiff and also paid rent for the month of March and April 2008 by hand. But the plaintiff did not issue rent as such. Defendant intends to deposit the arrears for this month, March and April. So, according to me, there is no admitted dues, there is no dispute regarding the allotted relationship. Whether this comes within the purview of 7.2 or not.
Where is your application under 7.2?
My lord, I have also asked. Only application is there, my lord, 151 page 78, your lordship file.
7.2 is not annexed.
And not, sir,
You have a copy of the 7.2
yes, that's
application?
the very beginning I am asking.
No, 151 for what?
This is for my lord.
That they have tendered the rent in the wrong court. For that
That's-
purpose, they wanted to.
No, this was not disposed of by the impugned order.
No.
Yes, my lord, they have also challenged the subsequent order. My lord, kindly looks at the order dated 16th June 2025. And this is also under challenge, my lord, wherein this 151 was dismissed, my lord. But two orders they have challenged in this instant revisional application. One is 3rd April 2025, dismissing their section 7.2 application. And the second one is the
No, it is consequential order in view of the rejection of 7.2.
But they have challenged this also.
I had to, otherwise, well, it will be.
Yes.
The 7.2 is normally considered whether, well, for the sake of repetition, my lord, I want. Well, what is the language 7.2? What dispute I can raise?
Dispute is whether any amount is payable by you or not.
According to me, my lord, it is not payable.
Yes, but since you have said that, yes, some amount paid, so that dispute you wanted to raise in 7.2.
Whether, my lord, if you logically in my written statement, if today I raise that dispute, yes, I have paid, I did not, that is why I did not for 7.2. Whether it is denuded for adjudication of the same, because by 7.2, I did not file 7.2 raising that dispute.
But Mr. Rai, there is one difficulty now. is if there has been an adjudication rightly or wrongly. Now,
That is why, my lord.
Rightly or wrongly, there has been an adjudication. You have
Yes.
paid. So there has been an admission on your part, and 7-3 is consequential now.
Precisely, my lord, can you consider whether 7-2, whether this order of 7-2 today, if the court is of the opinion, no, there is admitted you did not pay, I am out of court. I have to pay admitted dues along with that application within a period of 1 month. I'm out of court. There's nothing to do. When I say that, yes, I have paid, but I want I have to pay these 2 months because I do not have any receipts.
7-3 allowed.
Consequential, my lord, this is now consequential.
Has it been allowed?
No, my lord, subject to action, my lord, it is not. No, it is consequential. My lord's decisions are there. It is consequential. It is. So therefore, my lord, today has to consider whether this 7-2 can be considered as under section 7-2 or this is an application for determination whether there is a deposit. If the court hold that no, you did not pay that amount, I am out of court. If the court held that yes, you have paid.
Please, Mr. Rai, yes, you may not be said that you have to deposit that admitted amount because there is no admission. But the thing remains, you have approached the court for adjudication of a dispute that has to be within that time. Now it's
this is in the one of 7-2, and after allowing section 5, that after allowing section
that is one thing.
That is one aspect.
It comes within 7-2. There is no dispute with regard to that. It's your dispute which you have raised.
Yes, the dispute whether this comes within the purview of 7-2 or this can be adjudicated even if landlord.
Mr. Raj, if you say it's not a dispute, then you need not challenge that.
Court, the landlord trial.
It is you who have applied.
That is the.
Now you cannot say it's not applicable.
That is why I have to come.
Yes. Yes, sir. What do you say?
My lord, this is for the first time that this question has cropped up.
Which
in the plain, it was categorically averred that they are the defaulter for the month of March 2008. It was stated in paragraph 4 of the plain. While dealing with paragraph 4 of the plain, at paragraph 8, there is only bare denial of the fact that they are not defaulters. There is not a single whisper about the fact that they have paid the alleged defaulted sum for the month to the landlord by tenant by cash, and that.
Sir, what do you say to this order? Section 5 allowed.
Well, this
attain finality.
But the
Section 5 has been allowed, which has attained finality, binding between the parties.
No,
7-2 has to be.
May I make one submission?
7-2 has to be
40
decided on merits.
Under Section 40 of the Premises Tenancy Act will apply.
Sir, everything up to the last decision delivered on 13th of August 2025, it's in your favor. But what do you say to this?
This
fighting against you.
But I would say that an order which is erroneous, it will not bind.
Yes,
that is
Yes, unless challenge. Yes,
because of
what are you saying? It's res judicata. Even a wrong order is res judicata. What are you saying, sir?
Section 5 will not be applicable in this case, because of
you have not challenged this.
Admitted position we have not challenged, but Section 7(1)
only an authority, if it is a wrong order, not challenged, yes, the court can disregard it.
But Section 7(2), my lord, which my lord, kindly
grants me listening the court.
Grants me 2 days time, my lord, I'll come back with the authority, but I've not brought the authority.
Even if you say it's a wrong order,
it is not void ab initio. The order is not void ab initio.
It's a wrong order against the law laid down by the Honorable Supreme Court, against the provisions of the statute, but an order has been passed rightly or wrongly, not challenged, binding between the parties. What is the effect of that order?
Well, kindly grants me time, Sam. Well, I shall come back on Monday if so commences to
27, Mr. Rai. Suo motu power can be exercised.
Both the aspects, my lord. Yeah, my lord, it is the case I have shown to your lordship. The plaintiff himself said this amount is adjustable. Even if my lord Kali goes that way, my lord's judgment is not. This is reported 2024 my lord's judgment that it is not contrary to the law. They have admitted, yes, 6 months advance rate has been granted. So whether and 2 months rate, whether
yes,
in either way.
The first time this point is coming up, they have never agitated this point so far as
yes,
adjusting the rent, my lord.
Sir, adjusting is one thing that I will deal with subsequently.
Yes.
Please cross the first hurdle. Because
Section 5.
7(2) was not decided on merits. It was rejected only on the ground of limitation.
Yes.
After Section 5 has been allowed. That's what the hurdle in front of you.
Well, kindly grant me
Unless
time,
you
my lord, I shall
cross
come
that
back.
hurdle,
My lord, I shall come back with authority, my lord. I shall satisfy your lordship to that extent, my lord. Kindly grant me time till Monday, my lord, I shall come.
what is the next date fixed in the suit?
Some protection 7th is automatic. Now, my lord,
18th September, my lord.
18th September.
Yes.
There is substance in the argument.
We are appearing on behalf of the opposite party, decree holder.
Yes. Where are they? None appears for the petitioner at the time of call.
For the petitioner, my lord, this is the affidavit of service. Time to time, it has been extended by your lordship, my lord. Time to time, it has been extended. What I am saying, if your lordship fix a date after vacation, upon other side.
You have filed an application.
Yes.
Can 3.
Yes. Can 3. My lord,
An application for extension of interim order.
Eight and nine are similar matters. There are two
End of.
extension of interim order, my lord. The interim order expiring on the end of August, my lord. She will come.
You are for the opposite party.
I am for the opposite party.
The main matter is appearing in the list.
My lord.
The
Opposite party number 1. My lord, similar, my lord, it's my lord, in the
Same.
same agreement.
You are appearing for the opposite
And
party.
for the opposite party.
Same order. 8 and 9, same order. Next.
Item number 10. I'm for the petition.
Yes.
Pursuant to my lord's last direction, my lord, I have served. My lord, may I file my affidavit of service? My lord, execution proceeding, state, my lord, and the decree holder, no occupational charges.
You are for the petitioner.
I am for the petitioner.
Mr. Patwari, learned advocate.
Grateful.
Yes.
Deeply.
My lord, I beg to appear. Yes.
Petition. I am the plaintiff petitioner suit for partition, injunction and.
Yes. Baripur Court, do I have any difficulty in taking up?
I do not have any difficulty.
You may not have. I'm asking you, who is appearing in the Baripur Court?
But I have to take instruction.
Please come at 12. Take instructions who are appearing. Yes, next. Pass over.
12.
Yes.
Kindly make it short pass over, my lord. Mr. Munshi, he's coming, Mr. Munshi, so Speaker Munshi. Short pass over.
Pass over next.
Item number 13.
Lordship, the counsel appearing on behalf of the petitioner is unable to appear before Lordship due to some personal difficulties. For that reason, I am seeking a week's accommodation, Lordship.
By the order impugned, the application under yes, Mr. Gosar.
Railway without copy of it and expect only locker matter.
Yes.
I have complied with all the formalities. The court has passed an order of comply 316 because that is not 317. It's not applicable in our case. It is case of the applicant railway with copy of will annex, and it is after granting of probate, not before that. I have paid the highest court fees. Only no objection, no caveat, no nothing wrong is there. The application of railway.
No other heirs are there.
No complication is there. And it is my lord, the Lalet Judge has probably confused with the railway with copy of will annex. In case of a copy of will annex, 317 applies. Kindly see the first language.
It did not say 317. Did not say 317.
So that part should go. No other complication is there.
You have paid the highest court fees.
Yes. No complication about that. Only thing this court is confused that the with will annex is different thing. It is the administration, the probate, the executor. Kal see the first two lines.
One
Executor and
thing, Mr. Ghoshal, one thing which might have weighed with the learned trial judge, maybe because you have to pay the court fees, valuation of the,
I have paid highest court fees.
that must be one of the reasons.
Of course.
But you have not stated that you could have appraised the learned trial judge with regard to that.
Less sentimental. I should not say something before the court of law, before something. Court may, after human being may confuse something. We should be very cautious in using language about the court. Not applicable in my little knowledge.
But letter of administration proceeding is pending.
That is without will, only locker.
Yes.
Will is complicated.
No. I appreciate that. So this is LOA with regard to the locker only.
Only locker.
Only locker, and the that matter is fixed for argument.
Final here, order. All formalities are good. Citation, everything is complete.
But one thing, Mr. Ghoshal, in this, I think you have to serve the collector. Though there is no opposite party, theoretically you have to serve the collector. You can do one thing. You can do one thing because which district? Howrah.
Howrah.
You serve the collector as well as the government pleader.
As
government pleader, High Court, Calcutta, he can represent.
High Court, Calcutta.
Because theoretically, though there is no opposite party, but you have to serve the.
No. I have no objection, but the application is wrong application of that is given.
I appreciate that, but
in that case, the question order for 247 is there. Probability is the executor's power is there.
Everything is there, but what can be done?
Here it is only locker, only parents locker.
What is the next date fixed?
The date is in the probably in the.
That was 23rd of June.
Yes.
23rd of June 2025.
Last order.
Can you do one thing, Mr.
Well, kindly keep it pending. Then for a fortnight. In the meantime, I said take all these steps.
Yes, Mr. Banerjee. Mr. Rohan Banerjee is in the state panel. Ask him to come. Please wait. Pass over.
Item number 15. My lord, this is my application.
Mr. Rai is also appearing.
My lord, he was there previously.
Now he is a special counsel. If I am not wrong.
My lord, excuse me, kindly excuse me. Kindly see, my lord, the pilot knows it.
What?
With this reason, when judgment is the.
Yes, keep it with you. Please inform Mr. Rohan Banerjee. Yes.
My lord, my revision.
Ghoshal, do you have an extra copy of this civil division application? No.
Application.
You have an extra copy? All right. Yes.
My lord, my revisional applications is against the order passed by collector under the provisions of Bengal Demands Recoveries Act 1913. My lord, in admitted position, my lord, I was occupant and tenant of government, holding a specific area for public telephone booth in Nizam Palace. My lord, I used to pay rent, and my rent was supposed to increase within tenure of.
Order of eviction has passed.
Yes.
Including damages.
Including damages, asking for making payment of damages. But my
have you challenged that order?
No, my lord. My difficulty is that in the meantime, the recovery agency has initiated a proceedings for execution.
Yes.
So, my lord, kindly give me some limited protection through which I can prefer an appeal before district court. And
you approach the certificate officer. You approach the
certificate officer, my lord, for that. My lord, he says that no, since I am executing authority, so I cannot obtain any order from any.
No, where is that order? Please, have you approached?
Yes, on 26th of May and subsequent thereto, I appeared. But my lord, he says
26th of May you did not appear.
No, my lord,
because notice was issued to you.
Subsequent day on 19th of August, I appeared.
Yes.
But they says
where is the order of 19th of August? I allow you to appear there and to make submissions. Ashun. পাসওয়ার্ডটা দিন তো যেটা মিস্টার ঘোষাল আছে। Yes, Mr. Banerjee.
Item number 14.
Mr. Banerjee, this is a matter of a letter of administration. So there is no caveator, no party who is objecting to the letter of administration. Now, letter of administration is with regard to a locker, which was standing in the name of the deceased. Now, for the purpose of operating the locker, the letter of administration proceeding has been filed. Because there is no other side, so you know the procedure state or the collector has to be served. So I'm asking you appear for the state, take instructions, because according to Mr. Ghoshal, he has impugned order directed inventory of the materials inside the locker is to be made. He says that he has deposited the highest court fees. And if it is letter of administration for the purpose of operating the locker, take instructions or please consider.
First line is.
Please consider whether that is
An
necessary or not.
executor or administrator shall within 6 of a grant of probation.
Lordship, direct note, and a copy may directly, I'll take notice, but a copy may directly be served upon the
Yes,
collector.
I'm
I'll take.
directing Mr. Goshal's learned advocate on record to give you one copy and to serve upon the collector.
Fine.
No contest, now no.
It has been fixed for argument. You have been directed to take steps.
Stay.
It can be dismissed also.
Stay, dismissal of this divisional application. I'll get to the minor.
There shall be an order of stay of Yes, item number 16, yes. Who is appearing? None appears for the petitioner at the time of call. Please use the microphone.
I'm in person. I'm challenging the order of trial court, impugned order dated 2nd July, because this is a trust property which I am representing, and the order which has been passed by the learned judge, that I cannot stand as a order 3, rule 1 and 2.
Show me that order.
No, that order has not been incorporated, but he has a learned judge has told that you cannot stand. Second point,
that order has not been passed.
No,
and maintainability has been raised.
Maintainability has been raised on 340.
So when it is fixed for hearing?
29th of August.
So I'm directing that maintainability application to be decided.
And there is a judgment of the
Delay all the judgment, because I cannot decide, because no order has been passed on that. Cite all the decisions before the learned trial.
Already I have filed that judgment of the division bench of Calcutta High Court, where it has been categorical.
No order has been passed. It has been fixed on 29th of August for hearing.
Yeah,
you have already cited, let an order be passed.
But allow the order 3, rule 1 and 2 to represent.
That will be done. Let an order be passed. I cannot straight away from here make any observation. Yes, this application.
Lordship, I am appearing in this
Millet,
matter.
I appear for the Millet petitioner.
This is a
Millet,
matter,
in this.
Lordship, in which it involves a public
Millet,
premises.
I appear for the
This is
petitioner,
at
Millet.
near Shibpur, Havra. Now, a suit was filed in 2010 by one RK Transport Company, wherein
Millet,
your Lordship,
what is the order impugned?
Millet, it's an Millet application for
proceedings have
expeditious
been going on for
disposal.
quite some time, Your Lordship, and we had
What
filed
do you
several.
want?
Lordship, an expeditious disposal of the suit.
Expeditious disposal of
Suit, Millet, expeditious disposal of the suit.
It's an illegal, or unauthorized occupant who is there for quite some time. They're making illegal constructions, Your Lordship. Therefore, it is urgent that the suit be disposed of.
What is the stage of the suit?
Lordship, there is a status quo order. We have filed several applications. Written statement has been filed. We just want an expeditious disposal of the matter, Lordship.
Millet, I'm there for the petitioner, Millet.
What is the next date fixed?
2nd September.
For what?
Lordship, for hearing of all the applications.
What are the applications pending?
Lordship, we have three applications pending. One is an application under
Order
section 151
39.
directing the police officer to stop the illegal construction. One is an application for recalling of the order of status quo, which has been passed.
No. Millet, vacating has been
Asking
dismissed.
for a local inspector to be also appointed.
This application under Article 227 of the Constitution.
Millet, I appear. ভলিউম কমিয়ে রেখে দিয়ে কি মজা পায়
Yes.
The two application revision applications are there, 19 and 21. CO number 3002.
3002, yes.
The fight between the post of Mutwali between the petitioners and the opposite party number 3. And can you take up the
Whom do you want to add?
addition allowed? The sister filed an application for additional party to become a Mutwali on the ground that if you allow my brother to be Mutwali, then I have no claim over the Mutwaliship. But if you did not allow my brother to be, that is why. Precisely, before that, can I turn to page 42. This dispute is there since long. Can you turn to page 42, the revision application order passed by this honorable court. Can you turn to the next last operating portion, page 48. One got
yes.
The board of Waqf. Now got it. Last paragraph is to decide the respective claim to the office of the concerned Mutwaliship made on behalf of the petitioner as well as the opposite party number 1, and decide the matter in accordance with law, particularly in the light of the desire of the Waqifs as contained in the deed of Waqf through registered appointment of Mutwaliship. So this honorable court was directed that opposite party number 1 and the petitioner, these are loggerheads with the post. So it should be restricted to these two persons for the purpose of adjudication.
So according to you, this order is in violation of this order?
Yes. Our third party can be, and that too, I could understand the sister is claiming independent right. She said, if you allow
show me the
application that your lordship will find at page 60.
Page?
Yes, right. Yeah. Opposition. Yes. What? 101 muna. No, see it. If you logically turn to page 100, because it is my duty to also point it out to your lordship. This is a suit filed by the daughter herself, sister herself. Page 101, my lord will find.
That's the independent suit.
That is the independent suit.
Yes.
After that, my lord, she filed an application for
both of you are parties.
Yes.
In that suit?
Yes. Now, kindly turn to the application they she filed. Page 149.
Yes. Yes.
Paragraph 13.
Paragraph
13.
Yes.
Paragraph 12 is the proceedings initiated by herself.
Mr. Rai, both these OA 7 of 2022 and 11 of 2022 are hard analogously.
3 ways are there at present. Now, after causing the series of litigation, after that, the
Now,
Waqf was directed for joint Mutwaliship.
Suit or the three proceedings
Three proceedings.
Is with regard to the claim of Mutwali.
Mutwaliship. Joint Mutwali, the petitioner and the opposite number 3.
Of the same Waqf estate.
Same Waqf estate.
Now, Mr. Rai, what will be if these 3 proceedings are not decided analogously?
I could have understood this is an analogous trial. I could have understood. What? Why? What is the independent rights she is claiming? Can you turn to the prayer made by the
Page 159.
Can you turn to page one?
Mr. Rai, maybe you are right that you may say that merely because of that fact she may not be a necessary party. But since she has also made an independent claim.
That is why, my lord, can you turn to his page 158, my lord? What is the
No, but
prayer?
158 is what?
The prayer. Initially made the prayer for the
No,
purpose of
158 is not prayer. 150.
it is a board of walk-up, but because unless until you see
No, 156 is the prayer. Party respondent, order 1 rule 10.
that is order one rule 10.
Yes.
In the aid of this letter, because she by this letter she expressed her
Oh,
that is why page 150. So this is the
158, yes.
That as per my next page, my lord, 159.
Yes.
These are the criteria.
Who is Abdul Mojid? Will be the first Mutwali.
Second Mutwali. There is no dispute. He died. Now fight between.
Died without appointing his sons will be the next Mutwali.
Not a
dispute. No dispute on that.
No dispute.
Then in the absence of sons, the eligible persons among the sons of Sheikh Nadir.
Sheikh Kamaruddin will be next Mutwali.
Yes.
Here also there is
no dispute.
dispute.
Otherwise,
After that one, who is?
Otherwise, Molavi and 10 gentlemen of the locality will select a female or male amongst my descendants.
Everything is boiled down to Shat Charitra.
Gentlemen of the locality.
This boils down to Shat Charitra. Be as it may, I am not on that. In the facts, because the Honorable High Court, apart from that.
Mr. Rai, a female also can be appointed as Mutwali, male also. Now, if independent claims are there.
I cannot understand. That is why precisely I am coming. In the facts of the above circumstances, my humble request, kindly record the name of my younger brother Sheikh Moinuddin as the present sole recorded Mutwali. If he found not interested or otherwise, my name may be recorded as Mutwali. Whether it is permissible.
No, only one thing. If both of them are entitled, as per this,
then why it is
if my brother is not willing, if both are entitled, then maybe
for getting the Mutwaliship.
He is the joint. Maybe for abundant caution, they may say that if brother now backs out, so then myself.
Yes, then the suit. That is why you are independent suit.
Yes, that is why, Mr. Rai.
If that be allowed, one can consider whether it is contrary to the direction passed by this honorable court.
That is one way of looking at it, because at that point of time the other proceedings were not there.
And after that also, it is not that that ends. After the 2 rounds of litigation, suits, both the suits are there. After that, it is the third. But this, I could understand he's claiming independent to everything.
This OA filed by whom? You.
Yes. What by me?
No, this OA.
This OA by me.
And the
other one is other by Moinuddin.
So in both these OAs, she has been added. And the other is the
her independent.
It's the third.
I could, the best case is
yes. In the third matter, both of you are parties, and she is also a party.
Yes.
So that's the effective matter which can.
Yes, Mr. Van, one common evidence will suffice the purpose if it is a joint analogous trial. If not, what
are the stages of this?
Initial stage. There is no dispute of the same. More or less initial stage. It cannot be.
Actually, if she is added, Mr. Rai.
No, this addition one can consider if this addition is granted, on what premises? This is contrary to the direction. And what is the independent status? He filed a suit. She filed a suit.
Mr. Rai, one thing, at that point of time, the Honorable Division Bench was not aware of this fact that there is another person who is claiming.
No, this is the first time she is claiming.
That is why. That is why. No, the other OA, her OA is of which date? That is also 2022.
Yes.
So at the same point of time.
Well, 2004. The initial order is 2004.
Yes.
Directed the tribunal to consider the claims and counterclaim between the parties and passed an order.
Yes.
2004, that order was passed by Waqf board. Challenged before the suit court, tribunal. Did the suit by directed? No, you cannot, unilaterally cannot held to be the person Mohiuddin can be termed to be a Mutwali. So these are the criteria on basis of which you have to adjudicate who will be the Mutwali. Remanded. Again, order was passed. Same thing happens that contrary to the direction passed by the tribunal, order was passed. Set aside, directed for fresh consideration. After that, the board declared joint mutualship between the petitioners and the opposite party number 3. Now, after joint mutualship, now this joint mutualship is challenged by both the mutualis. So
And
therefore,
the third one is claiming independence.
then the third one is coming. I could have understood she has made independent claim, I could have understand. So that means you are now putting your head to at the issues.
What is your name?
I am Abdul Halim.
Halim.
Abdul Halim.
Yes.
And Sheikh Mohiuddin is the other one.
These are these both the persons. 21 is his suit.
There is substance. Yes, 20.
22. Right, number 20 is not my application.
Yes.
In nutshell, Milord, what happened? There was a complaint against me before the district forum under the Consumer Protection Act. But that final order has been passed, challenged in national up to Supreme Court confirmed.
Up to Supreme Court confirmed.
There is no hide and seek about it. Up to Supreme Court confirmed.
No.
Now execution was pending. In the execution proceeding, after the dismissal of the SLP, the decree holder initiated filed an application for issuance of warrant directly without any summons. On that day, one day in 2022, suddenly that application was taken up for the first time and directly warrant was issued. I filed 2 applications seeking stay of warrant. Now those applications have also been dismissed.
Which is the order we are challenging?
I have here the order I am challenging is the order dated 42nd order dated 20th March 2025. The second last order in Lordship's brief.
Second last order.
In Lordship's brief, yes. 42, order number 42.
Yes, order number 42.
This is impugned in this civil division application. Two MAs I filed for seeking stay of the application for issuing of for that now those have been
No, this was the stay was rejected.
yes. Now the
Whereafter the
no
stay order of any.
no, I'm here before your lordship for stay order. Now the parent problem is the order number 24 of 19th April 2024. That's at page 13. Page 113, sorry, 113. 113. This is the parent order which will have created all the problems. The learned advocate for the degree holder is present. He submits that judgment debtor has not complied with
What is the order which was put into execution?
The order by which the contempt complaint was allowed.
Yes, show me that. What is the order?
Main order allow হলো এটা প্রথম allow হলো annex করা হয়নি
What is the nature of the complaint?
That complaint is not maintainable. I am an education institution.
Now you cannot say that.
No, that point has not been taken. That point I am taking in the execution as well.
Yes.
Educational institute, they say my sanction was terminated from the mother university.
Show me the
lordship
order which has been put into execution.
But second annexure F, 2nd August 2019,
page
F, Millard, just 1 second. Page Millard, 83 Millard.
Page
83 Millard. Start from Millard 80, no, 80. Okay, annex.
No, where is the order? This
Only this page is annexed. The separate order sheet is not annexed.
Yes, where is that order? What have you have been directed to do?
Well, I have been asked to pay compensation
of
Millard the awarded sum.
What is the amount?
The amount Millard.
Secure the amount. I will stay this.
But only one point.
Secure the amount, sir. You need not pay to them.
Only one.
Money decree stay. You have to
I'm
secure.
not taking it say on the decree, Millard. Only one thing, Millard.
You are not. What are you doing? Execution.
She will give me 1 minute. She will give me 1 minute. She will give me 1 minute. That warrant has been issued without summons. But give me a
Please
chance.
secure the amount. I will stay everything.
But only warrant I am seeking stay. I am not asking for stay of execution.
So please secure the amount.
That page 35.
Please secure the amount.
Page 35 is that order.
Yes, please appear before the executing
I have been appearing.
You will not be arrested. Please appear and volunteer, obtain an order of stay. Nothing will be done.
Lordship will. I'll show me the lordship.
Secure the amount. I will stay everything.
If I will not secure, that I am an educational institute. If I secure the amount, it is absolutely not maintainable. Held by this court, by this court and also Supreme Court.
Amount will not be paid to them. It will be secured here.
But in any
obtain a bank guarantee, anything, any form. Please secure the amount.
I'll take instruction and come back. But because I am not seeking the stay of execution, I am only seeking stay of warrant. Because
not directly but indirectly.
Without someone's warrant is issue, I am every day I am appearing. Decree holder is not appearing. Lordship will kindly see the last orders. Last
even then
appearing.
If you are appearing, even then warrant.
Kindly, that is the contention I am making. Kindly see that from the last 10 orders, I have annexed the entire order sheets.
Yes.
Kindly sees who is present and who is not present. Order number.
You are present. No
I am every day present. He is not coming to court.
If you are present, you need not be worried with the warrant.
That clarification.
You need not be. I am recording that you are regularly present. On the next day also you will be present.
Yes, every day I will be there.
Yes.
So that there is no problem. The only thing is that
warrant. The amount, sir. What is the amount?
Amount is heavy.
Yes. Please secure the amount. I will stay everything. All proceedings I will stay.
The amount is 1,33,000 along with compensation of 1 lakh for damages.
Nothing.
Was 5 lakhs.
Please secure the amount. I will stay everything.
But kindly give.
2 lakhs is nothing. Please secure.
Take instruction and come back.
Please secure the amount. I will stay everything.
Very छोटा amount.
After some argument, the learned
Lordship is placed not based on record. It should be based on record because I am showing Lordship's the record.
Based on record, that is there. Your submission also have recorded. Everything is there. Double protection. No difficulty in that. Only secure the amount. Everything will be stayed.
Grateful.
Uh, Same order.
Only number 14.
Same order as in 19.
19.
As in 19, so the OA number 14 of
2022.
2022. Sir.
Yes, same. 14.
Yes, only 14.
Yes, next.
Order number 22.
12 weeks.
And 22, my lord, I think led by Mr. Mukherjee, my lord, he is online appearing.
22, my lord, I am appearing for the petitioner, my lord. But it's a complaint case, my lord, initiated by me before the Consumer Dispute Redressal Forum. Now, my lord, if your lordship kindly takes up page 637 once.
Commission.
Mr. Mukherjee, it's no longer the forum. It's now the commission.
No, my lord, it's commission, lord. I'm sorry. It's commission. Lord, if your lordship kindly takes up, page 37.
Yes.
My lord would get, my lord, there are numerous opposite party. Ultimately, on that day, on the prayer of the learned advocate for the opposite party number 64 and 67, they are not being permitted to file their reply, and that has been closed. And 21st of October 2024 is for final hearing. Your lordship has got that?
Yes.
Lord, kindly turns over the page 38. My lord, get, my lord, that the complaint and opposite party number 64 already filed, my lord, their brief notes of argument. It's in abbreviation, my lord, it's written as BNS.
Yes.
And my lord, the date was fixed, my lord, it's wrongly written 24, it's 15th of January 2025 for filing DNF by the opposite party number 68.
Yes.
If my lord turns to page 40,
yes.
Page 40, my lord would get 28. Again, my lord, it was adjourned and 28th of July 2025 for final hearing, BNA to be filed by the 68 in the meantime. On that day also, my lord, it has adjourned, and now the next date is fixed on 3rd of September. I may only beseech before your lordship that by the end of this year at least, let this be disposed of.
This,
but it's only for not even the brief notes of our.
This application under Article 227 of the Constitution of India, you are the complainant.
Yes, my lord, I am the complainant.
The instance of the complainant praying for a direction upon the learned West Bengal State Consumer Dispute Redressal Commission to Redressal Commission Kolkata to dispose of complaint case number CC/651/2018 expeditiously. First up, Mr. Mukherjee, learned advocate, appearing for the petitioner through virtual mode, submits that the next date the next date has been fixed on 3rd of September 2025 for filing the brief notes of argument by the opposite party number 68.
Malad, that has been done. That has been done. That was valid fixed on 20th of July. Malad, in the meantime, that has been done.
68 also
filed.
It's only for final argument.
The 3rd of September না ওটাকে তাহলে চেঞ্জ করে দিন 28th of July 2025 for filing brief notes of argument by the opposite party number 68 in the consumer complaint case. First up, Mr. Mukherjee further submits that the brief notes of argument has already been filed by the opposite party number 68 and the complaint case is otherwise ready for hearing. First up, in view of the order sought and proposed to the first paragraph, in the light of the submissions made by the learned advocate for the petition CO number such and such stands disposed of by requesting the learned West Bengal State Consumer Dispute Redressal Commission to make an endeavor to dispose of the consumer complaint to dispose of the complaint case number CC/651 of 2018 as expeditiously as possible without granting as expeditiously as possible, but preferably within a period of 6 months from the next date fixed without granting any unnecessary adjournments to either of the parties. 6, what? Yes, next.
Number 23.
Yes.
Your Lordship, this is application. All I'm praying for an expeditious disposal of my application filed under Section 8, read with Section 5 of the Arbitration and Conciliation Act. Lordship, the crux of the matter is in the instance
fixed.
Lordship on 25th of March 2026, next year, Your Lordship.
This application under Article 227 of the Constitution of India is at the instance of the defendant.
In a period that application can be disposed of after the next date, Your Lordship. If a
Yes. What is the next matter? Please call the next matter.
I'm for the petitioner, my lord. It's my application for expeditious disposal, Your Lordship.
Yes.
Petitioner filed an application under section.
What is the proceeding for?
Petitioner filed an application for under section 7, 10, 11, and 25 under guardians and wards, sir.
Who are you?
I'm for the petition applicant, Your Lordship. I'm for the petition applicant.
Yes, on 21st of August, it was fixed for production of
the minor child and so-called petition, Your Lordship.
Who is to produce the child?
Opposite party, Your Lordship.
It was done.
No, Your Lordship. Kindly seize the order copy, Your Lordship. May hand it over. The learned judge is not in session. Of most of the time, the learned judge is not in session, Your Lordship. May I direction
Cannot be helped from here. Yes, I'm coming after 5 minutes.
My lord, this is my revisional application, my lord. My lord, a title suit was filed for recovery of possession against my client, my lord. Then the summons were also served in 2018, my lord. My clients lost their only son who was only 12 years old, my lord. And they were in absolute trauma, my lord. So the advocate, my lord, they were themselves under the care of their relatives. Their relatives appointed a learned advocate, my lord, to take steps, my lord. He did not take any steps in this matter, my lord. Then, my lord, an ex parte decree was passed, my lord, on 22nd of April 24, my lord. Then the bailiff came to take possession. Against that, my lord, we filed an Order 9, Rule 13, my lord. No, that in that, my lord, we have filed affidavits, we have filed documents also. Your lordship would kindly come to the last page, my lord. This is
What is the order under challenge?
Yes, my lord, this is the order under challenge, my lord. This is the 16th order. May I read it out to your lordship? Junior advocate for the opposite party stated that the ex parte decree was passed on 22nd of April 24, and the judgment after file miscase number so and so under Order 9, Rule 13 for setting aside the ex parte decree. He stated that the judgment after lost his son 12 years old period, which caused immense mental suffering for her, and she could not pursue the case properly with the learned advocate. And she proceeded ex parte. Finally, the ex parte order was passed. He stated that the suit, this is important, my lord. He stated that the suit property is one single room, 119 square feet, sir, submission, my lord, and located in such a narrow lane where even two persons cannot pass together. He stated in their claim that the plaintiff admitted that the suit property can fetch only 1,500 per month. This is their statement, my lord, that this property, my lord, cannot fetch more than 1,500 per month as occupational charges, my lord. As rent, my lord. Next paragraph, my lord, the learned advocate of the decree holder stated that it is not one room, but one room and one kitchen on the first floor of the building. He stated that the premises is around 2 kilometers from the core premises in prime locality. He stated at least 5,000. This is their submission. That the room is not one room, it is two rooms, and the rent would be 5,000, and its premises is 2 kilometers from the city court, my lord. The next paragraph, my lord, from the
2
schedule.
kilometers from the city court.
Yes, my lord, city
No,
court.
no, actually,
That is a trial court, my lord. They are saying that it is 2 kilometers, this property is 2 kilometers from the city court, my lord.
what is according to you? It's not 2 kilometers.
2 kilometers, 4 kilometers, my lord. At least 4
2
kilometers.
kilometers around city court is in the heart of the city of Kolkata.
Lordship, I accept, my lord.
Even 5 kilometers if you take it.
Lordship, kindly come to the last paragraph. my
So
lord.
occupation charges 3,500.
My lord, this is, and well, the certain factors will have to be taken into consideration, my lord. For my lord, for the occupational charges, my lord, first is the location of the property, as if your lordship has stated, my lord. My lord, I accept it, my lord. Second is the nature of the property, the usage of the property, my lord. My lord, this is either it has to be commercial or residential, my lord. Our property is residential, so the my lord, the valuation would be much lower than the my lord, the commercial.
Residential property, what is the address of this property?
12B Rajan.
Amber Street, my lord. My lord, this is a dilapidated.
One room can be, you can get one room less than 3,500. Please shift there. Madam, please shift there. If you can get less than 3,500, it's better you get an accommodation. Why are you fighting out? Over and above this, there will be a litigation cost. So you will remain peacefully in a locality, that locality less than 3,500. It's better, madam.
Accept this, my lord, but this is a dilapidated property, my lord. There is a narrow lane in front of the property, my lord.
That is why.
My lord.
That is why if you can get at a lesser rent in that locality, please shift there. It's better at a lesser rent.
My lord, we don't have the means, my lord, because he's already retired, my lord. He's 70 years old. He has recently lost his son. He is in extreme trauma.
Madam,
Your
that's,
lordship would kindly consider this, my lord. He will not be able to pay this amount of money, and this is one room. Your lordship would kindly come to page 37, my lord. 38, your lordship. Your lordship would kindly come, my lord. This is the plan which has been made by an LBS, my lord.
What is the material you have produced before the learned executing court in support of your case for occupation charges?
My lord, they are saying this is 5,000 and 3,000.
No, they are saying baseless. I am asking you what is according to you, what document you have to show. It cannot be 1,500.
Well, I leave it to your lordship, my lord. But
I am asking you what materials you have in your possession to show.
Your lordship says, my lord, I can produce a valuation.
No, not here. I am asking you before the Lanet,
Before even we could produce a valuation report, my lord,
it is the state of the miscellaneous case. I can do one thing, I can expedite the miscellaneous case under Order 9 Rule 30. That much I can do.
your lordship would kindly, if they can kindly consider the occupational charges, my lord, we are only on that, my lord. But this is a dilapidated 150 years old property with only one room. Kitchen is, my lord, they are saying 2 rooms, my lord. We only have 1 room in possession because kitchen is a makeshift arrangement, my lord. There is no kitchen, only just 1 room, 190
It is
square feet.
coming 30 rupees per square feet.
It is coming to 30 rupees per square feet, your lordship. Lordship would kindly
Locality,
consider.
please consider the locality.
Your lordship would kindly consider this, my lord. Little bit lower, my lord, because
I'm telling you, madam, you must have much more experience. You will not get 10 kilometers even away from city court, you will not be getting at 3,500.
this is a very old tenancy, your lordship. Very
One
old
room.
tenancy, my lord.
Only one room.
Only 1 room. Very old tenancy in a dilapidated building. Your lordship would kindly consider make it a little less, your
I
lordship.
can do one thing, I can post it off after the vacations. That much I can do.
Lordship.
I can post this matter after the vacation only. That much I can do.
That is not, sir.
So after Janmashtami, it's only
Our purpose is, my lord, to
1 month
the-
left.
For purpose,
That
we defeated, my lord.
That much I can do, but for that
My lord,
I
should
can do that.
should
If you
I-
want,
my lord, if your lordship permits, my lord, should we get a valuer's report, your
Valuers
lordship?
report.
not here,
Then we
not
can-
here. Then I will appoint a valuer of the High Court.
If it's possible before vacation.
Before vacation, I am posting it after the vacation.
After the vacation. And
Your lordship.
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 After the
After vacations.
Thanks.
Under the heading motion.
Lordship.
Yes, next. Yes.
Item number 26.
But I appear for the but husband petitioner in a suit for divorce which was filed in 2013. But section 24 disposed of I am paying regular payments. My evidence is over. Now, what is happening is, my lord, my wife has to adduce evidence as OPW1, my lord, but she is continuously praying for time before the trial court. My lord, I have all her pending dues are cleared till May 2025.
Your evidence is concluded.
Concluded. My lord, it's only for OPW1, my lord, she has to come as my lord,
why OPW1?
My DW1. My lord, I stand corrected. My DW1, my lord.
Miscellaneous case is over.
He is disposed of. My lord, that order was challenged before this honorable court. This honorable court has
the next date fixed.
My lord, next date fixed, my lord, is in the month of August.
Of alimony pending
But 8 March 2017 was the initial order. My lord, thereafter, my lord, this court modified that order. Lordship would get that order. My lord, kindly comes to my lord, page 25.
Yes.
But pursuant to that, my lord, this honorable court reduced 7,500 to 2,500. And after that, my lord, I have been paying that amount regularly. But my lord, she is accepting money but not coming to depose. My lord, regular adjournments being allowed by the trial court. My lord, kindly, my lord, fixes a time frame. It's a
the order passed on 7th of May 2025.
My lord, 7th of May 2025. But that was, my lord, she had some areas, I have paid it.
Sir, you are not paying regularly. Why areas? You are not, this shows that you are not regular in paying the alimony.
No, my lord, whenever, my lord, she comes up with an execution case, it is kindly sees the earlier orders.
Then fight it out, let that be
My lord,
dragged.
could the matter be fixed, my lord?
Next.
Item number 27.
My lord, behalf of petitioner, my senior advocate Gautam Guria has admitted to the hospital for cardiac arrest due to early.
What do you want?
I am paying for some 2 weeks adjournment, please.
On the prayer of the
Item number 28.
to manage a short path. Short, my lord.
Please start. Please start. No Passover business.
But he is, my lord, on his legs, my lord. My lord.
Who is on his legs?
That's the manage.
Please start. Please start. Yes.
My lord, by two separate deeds, my lord, property, my lord, anti-marketed property was purchased, my lord, by the husband and the wife. My lord, in the deeds, my lord, the deeds have annexed, my lord. In the deeds also, it's, my lord, empty clear, my lord, that it cannot be, my lord, separated by myths and bounds. Now, my lord, a money decree was passed against the husband. My lord, the execution proceeding was levied. Now, my lord, the learned trial court, my lord, proceeded on the ground, my lord, learned executing court, my lord, proceeded on the ground, my lord, to attach the entire property by keeping open the condition, my lord, that it would be during the during demarcation, during the attachment, the property would be demarcated, which is not my lord, feasible. My lord, kindly.
Where is the decree? Show me the decree.
My lord, decree, my lord, the application, my lord, could not be annexed, my lord. It's a long pending matter, my lord.
What is the order under challenge?
Order under challenge, my lord, kindly, my lord, takes up
Order number 103.
103 and 101, my lord. Page 41, my lord, kindly comes. My lord, application under order 21/58 was page 29 is my application.
Yes, you are the wife of the judgment debtor.
My lord,
What,
kindly, my lord,
what is your deed number? What is the number of your deed?
my lord, 2161 is the deed of the wife.
2161.
This one. My lord, kindly, my lord, take some my application once.
2161 of 1997. And what is the deed of the husband?
160.
21. I think 2160 is your deed.
But 2161 is of the husband, 60 is mine.
That is why. So your property, your deed has not been attached.
My lord, deed is not being attached. My lord, kindly, my lord, take up
The property mentioned under that deed will be attached. No
Kindly-
difficulty in that. If you have an independent title with regard to your deed, yes, you will get that.
Kindly, my lord, take up the deeds once.
Yes.
Schedule of the deeds. My lord, page 16. The topo sheet.
Yes. Page
16.
Yes.
Page 16 is the schedule of one of the deeds, and page 24 is the schedule of the other deed.
Which one is yours?
Page 16 is my lord.
16 is your deed.
16 is 2160.
Yes, that is your deed.
16 is my deed.
And your husband's deed?
Page 24. My lord, kindly comes.
Yes. So the property mentioned in your husband's deed, the judgment data, that has been only attached.
My lord, kindly considers, my lord, the nature of the property such, my lord, my lord, attachment, if it is done, my lord, demarcation of the properties, my lord, these are inseparable properties, my lord.
Auction sale, you will get the share.
My lord, kindly considers, my lord, this scenario.
You deposed in the suit. Mr. Banerjee, you deposed in the suit.
No. In the suit itself.
Yes, yes. You deposed as a witness. Yes, yes. What is your answer? You have got instructions, I have seen. Yes, Mr. Banerjee, you have adduced evidence in the suit.
My lord, this, my lord, I have to, my lord, check up. The suit, my lord, whether I was, my lord, a party or, my lord, I...
No, no, you are not a party. I am not saying you are a party. You adduced evidence as a witness.
Well, Mr.
Yes, Mr.
Take over. No.
Yes, Mr. Banerjee.
We got the informed orders. Two orders we got are under challenge. Facts are not very nice. Little I must be the properties undivided and divided, no doubt of it. If I take the observations, the findings written by the learned man of the court, then the findings are not the observations are not in consonance with the ultimate decision.
Not in
consonance with the ultimate decision, or just the reverse, the ultimate decision which is under challenge is not at all in consonance with the findings written. The foundation of the ultimate observation.
Where is the decree?
The decree is not.
What is the nature of the decree?
Money decree. We have jointly as spouses. 9 kathas of land. Maybe a little wrong in figures. Undivided half share. The schedule of my deed and the schedule of my husband's deed exactly same.
Not same. Not same.
Undivided half share of.
Yes. So don't say same.
No. Undivided. The wording such
has to be because the plot numbers and other things is the same, but property is not the same.
Boundary work, everything. Now,
your portion has not been affected.
Yes, but there is no portion as such as on it.
That will be decided.
Portion as
that will be decided.
As a student of law, my little kindly correct me. I'm sure I am wrong. The rudimentary principle of attachment is what can be attached. The property which the judgment debtor is at the property which is at the disposal of the judgment debtor as on the date of the order of attachment is being passed. That is what is liable to be attached. The property, the order, impute order says effort should be made to, identify and, put a boundary to demarcate, the exact property of the judgment data. There, the learned court has done. In the guise of, attaching someone's property, the partition cannot. There, the learned court with, deepest of respect has done. I cannot say even for a while that, the undivided share cannot be. As an officer of court, I can't say that.
So if you cannot say that, so that has been shown. Show me that partition has been directed.
I have a look at page 41 plus 10 40.
41. What is page 41? No. What is that document at page 41?
It's order dated 13th May 2025.
No, that is not the certified copy. Yes. 101.
But I have marked it from the page in it.
Yes. Page 100, order number 101.
Yes, order number 101. Kindly have a look at 42, fourth last paragraph.
40.
Oh, I'm sorry, second. I'm sorry.
Second page.
Internal page 2.
Yes.
Fourth paragraph from the bottom.
Yes.
The objector, I was the objector, has failed to establish exclusive ownership independent of her husband's interest, particularly in view of the simultaneous execution of sale deeds and the lack of clear demarcation. So, the learned judge appreciates that it's not demarcated. The timing of the subsequent, etc. Now, kindly take the next order.
No, Mr. Banerjee, please complete this order. What has been done by this?
My objection is rejected.
No, thereafter, please proceed.
Wait.
Please place these 3 paragraphs.
Wait. A joint perusal of both sale deeds reveals that the husband and wife, the judgment debtor and the objector, had each purchased 9 chattaks of land. It's slightly incorrect. Undivided half share of 9 chattaks of land.
Undivided half share of
9 chattaks.
9 katas or chattaks? Not katas. It's chattaks.
To a person who have nothing, katas all are same. It's chatak.
Can we place it on record, Mr. Banerjee, your submission?
Kindly do so.
Yes.
9 chattaks of land from the
Yes.
same vendor through separate registered deeds executed on the same day with the same plot.
So what is the wrong observation here? Yes. Next.
I say, in the
Next paragraph.
the schedule and description of the properties are identical. Accordingly, it is held that the property purchased and held in the name of the judgment debtor is liable to be attached.
No, thereafter you have missed something. Under deed has been mentioned.
Yes, correct.
So that is the deed of the husband, judgment debtor, not the wife's.
Absolutely, no doubt.
So undivided share, you have said that it can be attached, and this deed contains the undivided share that has been attached.
Let us now come to the next one. But I say the conclusion of the
So this order, there is no defect, as you have said. Yes, 101. Yes, now let us come to 103.
This is 103.
Yes.
Kindly take first page of the impugned order, fourth paragraph from the bottom, which starts with it is also
First page or the second page?
first page.
First page, yes. Fourth paragraph from the top or the bottom?
It starts with it is also noted.
Yes.
It is also noted that the property purchased in the name of the wife and through registered deed number such and the property held by the judgment debtor under deed number such lie within common boundary wall without any physical demarcation and are being used as a residential unit. During the course of execution proceeding, proper measurement and demarcation shall be carried out to distinguish the portion of the here the learned judge gratified. This is the wish of the learned executor. This just cannot be done. That's what is passing through the learned court's mind, learned executing court's mind. This is a dangerous proposition. With all respect, this is something dangerous that has fallen from. This is not, permissible.
But the attachment undivided, that is permissible. 101, I'm affirming that.
Do not say that today.
Mr. Banerjee, you cannot take it. 101, there is no infirmity in 101. And deed number has been specified. Yes, Mr.
Seconds.
You can switch off the microphone also so that I cannot overhear you. You can switch off the microphone also.
Out of this discussion will reach your lordship only. But by Lalit Tulia, will not suggest that I should also indicate one more thing. But I have indicated that in my application. To catch at a straw as a traveling. I filed a suit under order feature. It's up to 5. The suit was.
Is that suit maintainable? When have you filed that suit?
It's the same.
When?
After my objection was rejected.
So during the pendency of the execution proceedings, whether such a suit is maintainable, Mr. Banerjee?
Might be a debatable question, but that is not
Might be a
debatable question.
Debatable. No debate. As clear. I can here and now make an observation with regard to your suit. Give me your plaint.
An informal discussion with your lordship when the occasion would arise, I will plunge into that. Today, that order is not there before your lordship. I just indicate the facts. The suit was placed, unlike other suits, before the Lalit Court, for admission.
That is not before me. I'm not going. I'm only going through these orders. Let me.
If my lord passes any order, so far as order number 101 is concerned, kindly make it my lord's observation.
No, I'm not recording your consent. I'm not recording your consent. I will not record your consent, Mr. Banerjee.
I am afraid of this live streaming now.
No.
I just share a very recent experience that I have passed through. I lead a matter. Then I am not very accustomed, familiar with social media. One of my juniors told me, Dada, look at this messages exchange. One of my clients castigated me in social media saying that I use the expression my lord too often, which makes my submission sound bad.
Question. This application under Article
possibly the only remedy. But I'll just consider once and come back. But from order number 103, but I need to take it to the higher forum. Leave to appeal possibly then would be the only remedy.
That you advise your client,
That
make your submissions.
did
then
not
I will
occur to me.
proceed.
Should have occurred to me. I was under an impression
Next,
one.
call the next matter.
29.
The 29, my lord, I am appealing on behalf of the petitioner. My lord, my defense was strike down by applying 7(3) of the Tenancy Act. My lord, the point is, my lord, 7(1) filed within time, court passes an order, we have deposited the admitted area of rent. My lord, in 7(2), I have raised the dispute with regard to the period of default that I have deposited some amount in the rent control. Pre-suit, my lord. The court has considered that my deposits are bad deposits. Maybe, my lord, but court did not give me an opportunity to deposit the rent, simply passes an order and my defense was strike down. That is not come under the purview of the amount admitted by him to be due. Whatever due which I have admitted, I have paid.
Where is the order dated 1st of July 2024?
Yes. Yes, my lord, my lord, I'm showing. It's in my phone, my lord. Only, my lord, the prayer was allowed to deposit the area rent which I have paid for in 7(1). Now that was allowed and directed me to deposit the rent as paid.
You have not deposited that.
My lord, admitted area has been deposited. But I am showing. Now that has been deposited. But I am showing. Well, the court has
no other option but to hold that despite getting an opportunity to deposit the areas of rent with interest, failed to comply with the order.
Yes, well, the court is considering that.
Give me a minute.
Yes, yes, well, I'm.
There is substance in the argument of the land. Yes.
I'm petitioner, my lord. My lord, it's the transfer petition.
Transfer petition
Transfer
means?
petition, transfer, my lord, MSC case from one tribunal to another under 227, my lord. Subject to correction, my lord, the 24 CPC is not applicable in case of transfer of MSc tribunal to another MSc tribunal.
From where to where?
My lord, from claim tribunal Bardhaman, first track, second court to Berhampur, my lord. Or any other.
What is
any
the
other.
ground
My
for
lord,
transfer?
difficulties are twofold difficulties. First problem is that the claimant is the practicing lawyer of Bardhaman court, my lord. We appointed a counsel, my lord.
Subsequent. Who are you?
I'm the owner of the vehicle, opposite party.
There is no insurance made.
No.
No insurance.
I think, my lord, subject to correction failed. Insurance failed. Insurance failed.
Insurance company is not a party.
Not a party. We appointed counsel, my lord, subsequently found to be reluctant, my lord. We made an objection before the local but to get an no objection.
This application under Article 2.
The petitioner is not present in the court, my lord. Difficulty is that no one is ready to appear on behalf of the petitioner, my lord.
Yes. Yes, call the next matter.
My lord, this is my application suit for eviction of licensing. My lord, I am the plaintiff. Not 7/12/2021 in ad interim injunction was granted. Defendant appeared on 14/7/2022, filed their WS on 24/3/2024 at belated stage, which was subsequently accepted upon payment of cost, my lord. Now, my lord, ad interim injunction is still now pending. Last date was 5/5/2025. Next date was posted on 24/10/2025. This is the situation, my lord.
24/10/2025 injunction application has been fixed for hearing.
Yes.
This application under Article 227 of the Constitution of India is at the
My lord, I am appealing for the petition.
yes. Expeditious hearing.
My lord, this is, my lord, the landlord's application before my lord, petition before my lord. My lord, rejection of my application under Order 12, Rule 6. My lord,
Landlord's application. Not 24th. 28. Yes.
Oh, Order 32.
Order 12, Rule 6.
My lord, Order 12 is stood rejected. My lord, kindly takes up item number 34 and 32. My lord, is the same. My lord, kindly takes up 34. Because that revisional application has all the documents annexed to it.
So this is to be rejected, Mr.
No, my lord,
Chatterjee.
what happened? This is for abundant caution. No order need not be passed in this because, my lord, two suits were consolidated.
34.
34.
32 and 34 দুটোই দিয়ে দিন এতে
এটা 34 টা 303 নাই
ওদের দুটোতেই লিখে দিন 32 and 34
Now, my lord, plaintiff is the petitioner before in a suit for eviction.
admission
My lord, admission is, my lord, the defendant admits that after the death of his father, my lord, he inherits the tenants. Now, my lord, father dies in
after
2015.
the death of father he inherits the tenancy.
My lord, father dies in 2015. Now, my lord, 5 years lapsed. My lord, my suit for eviction of a trespasser due to, my lord, elapse of that 5 years and, my lord, play of, my lord, 2G. My lord, this categorical admission was there in the suit. My lord, I filed the order 12 rule 6, my lord, saying that there is categorical admission of this, my lord, and no further trial should be, my lord, gone into, and my lord, judgment upon admission be passed. Now, my lord, the trial court, my lord, has said that a defense has been taken by the defendant that he is a tenant. Now, my lord, the defense that he takes, my lord, he is a tenant, is after, my lord, flowing from the after the death, my lord, his assertion is becomes tenant, my lord, after death of the father. My lord, that defense is no defense, my lord, after 5 years. Now, my lord, my suit is of 2023. But
Sir Chatterjee, that may be a no defense.
Absolutely.
That cannot be an admission.
Yes, my lord, I
There's
tell you,
a
lord.
distinction between admission and a no defense.
Now, my lord, I tell you, lordship, my lord. Here, my lord, the order 12 rule 6, my lord, says, my lord, otherwise, if court can infer admission, my lord, fruitlessly, my lord,
court can infer
my
admission.
lord, kindly takes up, my lord, Honorable Supreme Court has gone to that extent while deciding order 12 rule 1 and order 12 rule 6.
What is the stage of the suit, Mr. Chatterjee?
My lord, suit is, my lord, pre-trial stage. My lord, at this stage, my lord, what happened, my lord?
Interesting point you have raised. It requires admission to be decided. Interesting point.
My lord, kindly takes up because the trial court, my lord, if Lion looks into the impugned order, my lord, court has, and my lord, our honorable court has passed, my lord, a judgment, my lord, in to 2024, where in this situation, my lord, judgment upon admission has been granted. My lord, I was also viewed whether this kind of defense at all, my lord, can be considered to be an admission or not. My lord, I found, my lord, on research, my lord, honorable Supreme Court in such cases is inferring admission. Not only that, my lord, and
it's saying under order 12 rule 6, inferring admission.
My lord, yes, my lord.
Yes, show
Kindly
me.
takes up order 12 rule 6.
Yes, I am at order 12 rule 6. This expression or otherwise?
Yes.
Show me the judgment.
Yes, sir. 2010-5 দুটোই দেয়। But I am relying upon 2010 4 SCC 753. Kindly looks into this.
Yes, where it has been.
Oh, office copy টা দিয়ে দিলাম দর্শক। My lord, my lord, my lord may take up. My lord, kindly takes up, my lord, this one that is marked. My lord, easier for me to, my lord, indicate. That is marked, my lord, kindly takes this up. My lord.
Easier for me
Hey,
to
ওটা
look into
ওটা
those.
my lord,
Skip those paragraph with reading. You take that. Yes. I did. Yes, paragraph.
Yes. Now, my lord, here what happened, my lord? Trust was taking a defense, my lord. The landlord is denying the title of the landlord. My lord, briefly, factually, what happened, my lord? Now, my lord,
which paragraph you are referring to?
My lord, kindly takes up, my lord, paragraph 26 first. My lord, factually, my lord, to indicate what was happening.
Please show me that paragraph.
Yes.
I was right at that paragraph.
Yes. My lord, kindly takes up paragraph number 39.
Yes. Please give me a minute.
39 to, my lord.
I will come back to you. Please give me a minute. Yes.
So,
Now
Milord,
come back to the facts.
yes, Milord, what happened, Milord, here? Milord, defense was taken by the Milord defendant that trust is not the owner. And Milord, suit was Milord on the count that there is a default of rent. Now, Milord, the admittedly one admission was there, Milord. Yes, there was no payment of rent. But Milord, on the contrary, Milord, why no payment of
That
rent?
admission was there.
Milord, 114 application was made by the trust where they say we want a Milord release from this forfeiture on, relying on the terms of the lease. Now, Milord, Supreme Court says that if you make and stand that I want Milord a forfeiture, Milord, under 114, and Milord come up and say that take a defense that is
admitted.
default is admitted, and Milord, you cannot deny the title in different taking an inconsistent plea. So, Milord, now Supreme Court is drawing an inference
Now show
that
me
this
the
is
judgment. Show me the judgment. Impugned order.
yes. Milord, can you text? Milord, kindly takes up, Milord, the impugned order last portion, Milord, just before the ordering portion in the present case. What has found, Milord?
Yes.
In the present case, defendant has nowhere admitted the case of the plaintiff clearly and unambiguously. Hence, the statement of the defendant made in the another suit, title suit number 1743, in respect of death of the father, is not sufficiently treated as admission for the purpose of applying order 626. So, Milord, two suits as I was referring. Milord, in his suit, Milord, claiming to be the tenant, Milord, this is title suit number 1743, where he says that after father, he inherits the tenancy and he is continuing possession.
This suit, that was not the case.
In this suit also, this was the case.
Yes.
But Milord, with an addendum that he has paid rent on one liner. But in the other suit, he says that defendant has not been issuing rent receipts in his suit, and I am being tenant after the death of the father. So, Milord, this inconsistent stand in two suits. Milord, saying that but one admission, landlord-tenant relationship admitted that I am the landlord, he says he is the tenant. To that extent,
Father died in 2015.
father died,
5 years.
and Milord, he is claiming his tenancy on the death of
Anything
father.
more, Mr. Chatterjee?
Milord, kindly takes up, Milord, this suit, Milord, once, Milord, this 1743. Why I say, Milord, this is admission categorical, unambiguous. Milord, kindly takes up page 37.
Yes.
Kindly takes up paragraph.
This is the present suit.
No, this is the other suit which he filed, Milord, in 2022, seeking a declaration that he is a tenant in respect of the Milord premises in
Evidence
question.
has not yet started.
No, this was consolidated. These two suits, my suit and his suit, was consolidated by order of this
Suits are
court.
consolidated.
Consolidated.
Yes.
Now, Milord, paragraph 2 of this suit.
Yes.
The plaintiff states that originally father of the plaintiff, namely Raja Ram Shah Gupta, was the tenant in respect of the suit property, and after his death, the plaintiff, being son of the suit shop room, inherited the right of tenancy and also been carrying on business thereon with having all valid documents, name and style, Mrs. Gupta Steel Udyog. He has been carrying on the business in the schedule mentioned property for a long time. The plaintiff has several documents to prove his possession. The plaintiff used to pay rent, maintain khata, the account of rent since induction. The plaintiff has trade license, such and such, such and such. So this is the statement that after death of the father he is carrying. Father dies in 2015, no denial. Because in my suit he doesn't deny that.
No, in this suit, it did not say the date.
No, he doesn't say the date.
Yes.
And in my suit, Milord, I say the date that there is no
Then
denial.
there is as such no admission with regard to the fact of 2G.
No, Milord,
From here, you cannot draw the admission.
so, Milord, 2 has to be looked into.
So, I'm looking
Yes,
it
yes,
side by side.
yes, yes.
From this 2G cannot be
No,
inferred.
from this G cannot be.
Yes. Now, please come to the written statement of that suit.
Milord, this suit.
Yes, present suit.
Present suit.
Yes.
Yes. my lord, kindly takes up my plaint first, then my lord, his written statement.
Your plain there will be no admission.
No,
You
my
want
lord,
a judgment
admission,
of-
if there is no denial, that's admission. If there is no denial, then there is an admission, my lord. That's also, my lord, Honorable Supreme Court is saying, my lord, on that count.
All right.
My lord, kindly takes up my plaint at page 15. Relevant paragraph 5,
Yes.
4 and 5, my lord, Raja Ram Shaw alias was the original tenant, and 5 is the date of death, 6/4/2000.
For which portion he was the original tenant?
My lord,
Yes, Rajaram
Raj-
Shaw was the erstwhile premises tenant.
Yes.
Yes, say, died on or on Bob.
Paragraph 5, my lord, on or about 6/4/2015.
Yes.
Now, my lord, kindly takes up his written statement.
Yes.
My lord, kindly counts the assertive statement he made in internal page 5, page 26.
First show me how he has denied this 4 and 5. You have said it has not been denied. So let me first see how they have dealt with paragraph 4 and 5.
Very good. Paragraph 4 and 5. My lord, 9. 9 is the denial of death, but he doesn't
So
say when his
denial
father
of-
died.
No, date
Denied.
of death he has denied.
He doesn't disclose the date of death.
That is a different thing altogether. But he denies your statement.
That 6/4/2015 denied, but he
Yes.
doesn't say when his father dies.
And he takes a positive stand that being the son of the original tenant, that also he is
Yes,
denying.
admitting. Yes, that is it. Now, my lord,
Your statement is that your case is not under 2G.
my lord, my case is trespasser because of applicability of 2G. My plate.
How can it be?
Because after 5 years,
Immediately after no, you have said-
2015, my lord, my case is a 2015 original tenant died. I filed suit
and
in
paragraph
2020.
5 says from 2015 is a trespasser. Cannot be.
No, my lord, my suit is of 2023.
Maybe, but you have said since then it's a trespasser. That's your pleading.
No,
Paragraph 5. Since then means since 6th of April 2015. That's your pleading.
because he was not dependent, my lord, he would not, my lord, other criteria of 2G, my lord, comes into play. And now, my lord, 5 years have passed, 2023.
Not expressly stating that in your plaint.
No, my lord, this paragraph 6.
So everything is vague.
Paragraph 6.
Yes.
Expressly stated in my plaint.
Yes.
Applicability of 2G.
Yes. Applicability of 2G you have stated in paragraph 6. That's the point of law.
Yes. Point of law.
Yes.
Now, my lord, on this count, my lord, his assertive statement starts from paragraph 15 of his written statement, page 26.
Page 26. Yes.
Written statement. My lord, the defendant submits that after death of his father, Raja Ram Shaw alias Gupta, the defendant has been possessing the suit property continuously as premises tenant under plaintiff number 1, and the plaintiffs their rent collector, namely Shivadatta such and such, my lord, collected rent up to January 2023 by signing document even after filing of this suit. Now, my lord,
is sure that
nobody knows. Nobody knows because now I will take my lord to his suit where he says that's why I will not shown 2010.
Chatterjee,
kindly
these
takes
are all disputed questions of fact.
kindly takes.
So he says that he's paying.
No, my lord,
These
he
are all
doesn't say so in his
questions
suit.
of fact.
He doesn't say so in his suit. In his suit. My lord, kindly, that's why, my lord, Honorable Supreme Court says, my lord, this kind of appropriate, reprobate. And my lord, 2005 also I'm carrying, my lord, where it says inconsistent pleadings. My lord, is not permissible, and if court sees that that pleading is directly in conflict with the other pleading where he intends to rely upon, an inference of this
And,
attachment can be done.
Order 12 Rule 6 also can be used suo motu.
Can be used suo motu, yes.
I will remember this. Please give me those judgments. Please give me those.
Well, I'm carrying this to now 2005-11.
Yes, give me. So suo motu that can be used, I will keep that in mind.
Are Baba.
Pleadings. Yes, so on the basis of that, judgment on admission can be passed.
No. Well, this is 2005-11, relied by 2010 also.
Yes. It has been relied upon in Charanjit, it has been.
Yes, relied.
Which paragraph?
Well, this is relied, paragraph number, relevant paragraph would be, paragraph 7 is the longest paragraph, 7 and 8.
Portion.
Milord, 8, Milord kindly comes into Milord.
Yes.
My lord, paragraph 8, learned counsel made an alternative submission. The revision petition was not maintained and the lease deed is not a registered one and therefore it is not maintainable. None of these have been raised by the defendant before the learned single judge. Even before the trial court, the non-registration of lease deed was not put in issue. It is only devised now to somehow defeat and delay the eviction position of the premises to the landlady. In fact, Order 12 Rule 6 is enacted for the purpose of in order to expedite the trials if there is any admission of the defendant or an admission can be inferred from the facts and circumstances of the case without any dispute. Then, in such a case, in order to expedite and dispose of the matter, such admission can be acted upon. In the present case, looking at the terms of the lease deed, there can be no two opinions that the tenancy was joint composite and not an individual one. Therefore, on this admitted facts, the view taken by the learned single judge of the High Court appears to be justified. In this connection, Milord, the decision was relied upon. Milord, same quoted there also, Milord, and Milord, admission was allowed, suit was allowed. Milord, what happened here, Milord, the defense of this type, Milord, it was not a composite tenancy, it's individual because there are letters seeking individually payment of rent. Supreme Court or the High Court, Milord, got diverged into those letters, said that from this letter it can be inferred that it's nothing more, Milord, rather the composite tenancy. So therefore, Milord, trial court erred, Milord, is that not looking into that suit. Milord, trial court restricted in the Milord pleadings of this suit. Milord, had it that suit of those, Milord, in which he is relying upon, where he categorically says, Milord, I have never accepted him a tenancy, rather I am disturbing his possession and trying to evict him without due process of law. That's why he has come to court seeking a declaration of tenancy. Milord, in that suit, he says, I have not been issuing rent receipts, and Milord, I am threatening him to evict. So, Milord, there the categorical admission infers, Milord, now when I file a suit, he adds the name Sheodotto, that somebody rent controller is collecting, and we don't know this rent collector. And Milord, he says, Milord, that
I do not know him.
I do not know him. Now, Milord, he says, and rather, Milord, he says that rent collector recognized him as a tenant, not the plaintiffs. Milord, this is very important in this suit. So, Milord, these two.
West Bengal Premises Census Act.
আরে সার্ভিস করে আসছে এত যদি দেখছে কি হবে? As I come back, Milord, after service, Milord, I'm not praying for stay. Let me come back.
You are not paying for stay. What is admitted in this type of a suit, stay has to be granted automatically. It's the important point which you have raised has to be decided. Stay has,
Milord, it's something interesting, Milord, I say, Your Lordship, Milord. This defense, which has no bearing, two suits are entirely different.
Yes.
Milord, Malad has looked into, Milord.
No. You make your submissions. You have said rent collector is not a rent
Milord,
collector.
one who collects rents, Milord, ownership, Milord, that issue, Malad is going into.
He's collecting. What is the effect of that? That I will consider.
Yes, Milord, at the same
But
time,
Mr.
Milord,
Chatterjee, don't say all these observations without being swayed. You are making these submissions. After an order is passed, all these observations will remain.
No, Milord, I would, Milord, humbly submit before my Lord, Milord, to confine my Lord to this pleading in his suit.
Yes,
Milord, Order 12, Rule 6.
Pleading in written statement in your suit, plaintiff in his suit. Only to that, nothing else.
More, Milord.
And the implication of that.
Milord, where?
Implication of that, not inference. You have said inference.
Yes, Milord.
Can be inferred for the purpose of Order 12, Rule 6. What's the natural inference that can be drawn? That I will make observations with regard to this.
Milord, then kindly turns to that paragraph where, Milord, I would rely, Milord, at paragraph 4 at page 39 in his suit.
Yes. Yes.
Well, that initially the plaintiff did not take the threat so seriously, but the defendant, in order to dispossess the plaintiff, started various disturbing activities in front of the suit property. The plaintiff states that he was or is the premises tenant in respect of the suit property. His father was a tenant of the suit property, and now after the death of his father, the plaintiff became tenant under the defendant. Kindly marks this, Milord. The plaintiff
after the death of his father, he became the tenant.
The plaintiff has right to occupy the tenant as described in the schedule below as tenant until and unless the plaintiff is evicted in due course of law. The plaintiff also paid regularly, but the recently defendant did not issue rent receipt, and for this reason, he maintains khata where the defendant signed the same on receiving rent. Plaintiff craves the leave, such and such. Thereafter, paragraph 5, my lord, I have claimed from him higher rent. That's why, my lord, I am threatening him to evict and disposes. So, my lord, I have nowhere accepted him as a tenant. This is first categorical admission. He doesn't say a fresh tenancy is being created by issuing a rent receipt in his name. No pleading of to that extent that no new tenancy has been created. His claim is from the death of his father. Milord, therefore, Milord, in this case, Milord, I would say, Milord, why this trial court has not looked into this part and Milord
I'm
said,
looking into this part. I will look into this.
if I may say, Milord, my lord, may
Look into this part. I will look all these pleadings.
My lord, then, my lord, only thing, my lord, I would humbly submit, my lord, one more decision of this honorable court where this specific case, my lord, Thampa Sarkar, reported her. Siege is কোন জায়গাটা বল?
For what proposition?
My lord, same, my lord, 2G applied, judgment upon admission granted. My lord, I'm sorry, my lord, I could not get it online, print out about the book. My lord, issue of payment of rent came into, my lord, there, my lord, my lord, same property devolved from the original tenant. My lord, 5 years passed.
Anything more?
Probably anything. Well, these are my humble submissions.
This application under Article 227 of the Constitution. Yes, call the next matter.
Number 33.
There's a match shoot my lord file and my lord for speedy disposal of the match shoot before the learned court below, my lord.
Who are you?
I am the my lord husband, my lord. And my lord, my mother, my lord, was also ousted, and I am also ousted from. I am living, my lord, in a rented house.
What is the Viscous 7 of 2024 for?
That is a section 24. Has also filed.
That is still to be disposed of.
No, yes, my lord. All
This application under Article 227 of the the first disposed of.
If not, I'm appealing for the opposite party number one. I'm pleading for not to them. I'm seeking just as the accommodation. I'm pleading for not to take.
Chakraborty, his court number 11 lordship, they wants to take time lordship.
Lord, may I come back tomorrow, my lord? Item number 35. I'm for the opposite party number one.
Come at 2 p.m.
Not made tomorrow, my lord. Kindly,
Why
my lord.
tomorrow?
Not prepared. My
Let
lord, yesterday only it has been
Let us
started.
see if it is a fit case for admission. Ask him to come at 2 p.m. Yes, call the next matter.
Order number 36.
36, my application for expeditious disposal of a title suit pending since 2015, my lord.
What
The
is the stage of the suit?
hearing for Order 5 Rule 20 application. The principal defendant
Order
appeared
5 Rule 20.
Order 5 Rule
application is
20
pending.
because of substitution application. Substitution
Yes.
application preferred on
How
3
come the
applications.
suit be expedited now?
My lord, kindly cease.
Application
My
under
lord, kindly
Article
cease
227 of the Constitution of India is at the instance of the
Item number 35.
Yes, call the next matter.
My lord, 37 is the expeditious disposal. So, since 2000,
Who are you?
my lord, I am for that application, my lord. My lord, it was a transfer divorce petition from Bandra, Supreme Court has transferred, and it is file of need.
Any annually application has been filed?
No, my lord.
This application, what is the stage of the suit?
My lord, summons has been issued.
Summons has been issued.
Summons has been issued only. Since 2000, kindly says the date.
Sir,
4 months date has been given.
the suit is not ready for hearing. Can a direction for
Kindly make an endeavor to dispose it of within, at least.
even if the summons is not served?
Summon has been served. They have not appeared. And kindly says the order sheet annexed with the last page. My lord, the first date was the 6/11/2024 after Supreme Court transfer. We have appeared, we have filed the summons. Supreme Court has given us the liberty.
I did not appear on 20th of March.
My lord, Supreme Court has given the court has not recorded. Supreme Court has specifically given us liberty.
This application under Article 227 of the Constitution.
Has been filed.
That is why I said
if any has been filed, can kindly mention. Else,
I said not default. If there is no application, you are not at default.
Grateful, my with regard
Thank
to
you.
item
Yes, call the next matter. Hoi geche.
Item number 35.
May I
Dear ballot,
May I come back tomorrow, my lord, maybe.
My lordship is asking for a time, my lord, at 2 p.m. I have a matter fixed because of your lordship released the matter, assigned 2 p.m. first matter. My lord, may I come back tomorrow?
I will take some time to hear them. You can in the meantime join.
I am the petitioner. I am ready otherwise.
He's the petitioner. I am the opposite party number one. Lord. May both we come back to tomorrow, my lord.
Then it will be adjourned.
My lord, kindly back tomorrow, my lord.
Yes, call the list.
Lord, only one humble prayer, my Lord, may I just make, my Lord, tomorrow, my Lord, there is a matter would be coming up as new motion, my Lord, but I will not be here tomorrow. May I just ask my Lord to place it on Monday, my Lord? Otherwise, it will go down to bottom.
Call the list, call the list. Yes, next.
Monthly matter, my Lord, may I be permitted to mention one matter, my Lord? There is an urgency, my Lord. I need leave to file this matter so that I can move the matter tomorrow, my Lord. There's some urgency, my Lord. My car will be taken away by the financial company, my Lord. They have already taken the car.
When the order was passed.
My Lord, order was not passed, my Lord. The financial company has taken the car. The financial company has taken the car without
taken the car.
They are in possession of.
It will appear, no.
My Lord, we have already paid the entire amount, my Lord.
File it will appear, not tomorrow. Yes, call the list.
Item number 523 monthly list.
Yes. Yes. Yes, who is appearing?
Lordship, I'm appearing on behalf of the opposite party. Lordship, I pray for short passover, Your Lordship. Very short
You are for the
passover.
petitioner.
No, Your Lordship, I'm for the opposite party, number one.
Petitioner is not here. None appears for the petitioner at the time of.
Item number 993.
Lordship, I appear for the opposite party.
Yes, yes, Mr. Shah.
May I request your Lordship to have it sometime in the first week of September?
Mr. Shah, it's difficult to fix now because these are the upgraded matters. It's difficult.
Actually, I was not aware that it would be taken up today. Any day, my Lord, I'm not, my Lord, asking for any, my Lord, preference, my Lord. Any day that is convenient to the court, my Lord. I would have to be present, my Lord, before your Lordship was.
On the prayer of Mr. Shahal and his senior advocate appearing for the petitioner, a hearing of the civil division application stands adjourned. Yes, next.
Lordship, the DRT matter is fixed on the 29th of August. This matter has been pending since April 2024, because of which the DRT is not proceeding. I'm out of pocket since 2014, Lordship.
Interim order is there.
No, Lordship, there is no interim order, but the officer at the DRT.
If your Lordship will treat it as a joint prayer, my Lord, any day, my Lord, convenient to the court.
Lordship, may be kindly consider passing that order that there is no
Please make that submission. You are saying that there is no order of
Lordship, I am for the
Lordship,
petitioner.
the honorable presiding officer declines to hear the matter on the count of pendency of this. I've been trying since April 2024, Lordship.
Pendency cannot be a ground for not proceeding.
Outright.
Apprise the learned DRAT for that. Yes,
Lordship, if you have to consider passing some observation on that account, Lordship, because I've been trying for 1 year to get the matter heard, Lordship. I'm out of pocket since 2014, Lordship.
You have mentioned this matter.
Lordship, the other side, in fact, mentioned it in July, and it got upgraded in August.
I am only seeking, my Lord, day's accommodation any day, my Lord, that is convenient to the court, my Lord, I'll be there.
The matter tomorrow, let it retain its position in the list, Lordship.
Possible. Let me adjourn. Thereafter, I will consider. Yes, call the next matter.
Item number 662 with 663.
I am for the petitioner. My
Lordship,
these two matters has been taken up analogously in
Yes.
presence of both the parties. The fact is that, my lord, land acquisition proceedings.
Yes.
Compensation award has been declared. There is no dispute or nobody challenged the amount awarded.
Yes.
But opposite party claims that there is some right over the property. Matter referred to civil court.
Yes.
Learned civil court, after hearing both sides, held that earlier the petitioner filed a civil suit declaration of title, and in that suit the father of the opposite parties are made party. That suit declared in favor of the plaintiff. Therefore, they have been right of interest over the property which has been acquired for the public highway or something like that. Now, my lord, against that order, judgment and decree, the opposite party filed a revision application. And learned judge is of the view, unless the revision application has been disposed of, the awarded amount cannot be disbursed.
Where is that?
Well, I am appearing. 662, I am for the petition.
You are appearing for whom?
662, I am for the petitioner.
662, you are for the petitioner. And Mr. Das, you are for
663.
Oh, 663.
Lordship, can you see order number 65 dated 21st March 2022. It is 663.
663 দিয়েছেন 7 662, yes.
Yes, it has to be heard first because 663 is, my lord, since the.
All right, you place your case.
But this matter, my lord, relates to land acquisition under
Yes.
National Highways Act. National Highways Act, but section 3H4 is the relevant provision. My lord, where, my lord, the matter was relegated to the principal court of civil judge, my lord. But there, my lord, the order was passed taking into consideration an ex parte decree which is already challenged under Order 9 Rule 13 and the said miscase is pending. Now, my lord, so far as the title of the.
Against which Order 9 Rule 13 is pending? Against what order?
Against an ex parte decree based on which.
But a decree passed on when?
Well, it passed
22nd December 2023.
22nd of December 2023.
Lordship.
So, against this order, Order 9 Rule 13 is pending.
Pending. Not only that,
Your
but may I tell you, Lordship, my lord, the entire matter, the crux of the matter is very.
No, but you have challenged this order here.
I have challenged this order here because, my lord, ignoring the pendency of the ex parte order, my lord, here, my lord, the apportionment has to be done, my lord, determining the right title and interest of the parties. So, my lord, originally, my lord, the plot was, my lord, owned by 3 persons, my lord. Amritlal, Narayan Chandra and Paran Chandra. Now, this is Amritlal.
No, by this it was held that the petitioner Manoj Kumar Bhattacharya is entitled to get such and such on account of acquiring his portion and is permitted to withdraw. Who are you? You are Manoj? No,
my lord. I am Manoj.
He is Manoj.
I am Manoj.
Yes.
He is Manoj.
How are you related?
My lord, may I tell you, Lordship? My lord, he is Manoj. My lord, this Amritlal, Narayan Chandra and Paran Chandra are the original owners. Now, this Manoj is, my lord, the descendant of Narayan Chandra. And, my lord, I am the descendant of Amritlal through Tarapur.
So, this order was passed ex parte.
This order was not passed ex parte.
That is why I am asking you, which
the
order?
impugned order is not passed ex parte.
Judgment and decree passed ex parte.
The judgment and decree.
Where is that? Please show me that.
Yes, my lord. Kindly allow me, my lord. This is, my lord.
And Mr. Das, you are also challenging this 22nd of December 2023.
My lord.
What are you challenging?
I have challenged, my lord. The learned court says the revision application filed unless this revision application is disposed of, the amount cannot be disbursed. But no stay order is there from this court. They only filed the revision application, and more, my lord, it is an appealable order. Revision does not lie.
No, on that point, my lord,
it is an appealable order. How they filed revision, I fail to understand.
So, since this civil revision application was pending, an adjournment was paid for 704 of 2024.
Yes.
Yes. Yes, Mr. Rai. What is
now, my lord, the original owners were Amritlal, Narayan Chandra and Paran Chandra. My lord, Amritlal was the owner of half of the suit plot. Narayan Chandra and Paran Chandra were the owners of 1/4 of the suit plot. To this extent, my lord, facts are admitted. Now, my lord, this Manoj, my lord, claims his title. My lord, he is the son of Narayan Chandra. My lord, Narayan Chandra, during his lifetime in the year 1953, transferred.
What is your name?
My lord, I am, my lord, Sadhun.
Your name is recorded in the record of rights.
My name was recorded, my lord. This case has a checkered history. My name was recorded. Thereafter, it was struck off. Thereafter, again, my lord, the matter was remanded. Presently, it is also pending before the DL and LRO.
No, that is disposed of, my lord.
No.
By showing my client was dead, where their persons has been recorded.
By
the orders of High Court, it has been removed and rectified.
My lord, my lord, previously, there were some collusive title suits, my lord, involving the share of Tara Prasanna, who is the,
Which decree you have challenged? Show me that.
my lord, I have challenged, my lord, TS 64 of 2004, which was
Yes.
decided on 20/12/2007.
What was the suit for?
My lord,
For
suit-
declaration and
suit for
permanent
declaration,
injunction. Declaration
for
of title
declaration
and
and
permanent
permanent
injunction.
injunction.
Lordship, can you see page 9?
Decreed ex parte against the defendant numbers 1 to 4. You have the defendant numbers 1 to 4.
4 was his father, my lord.
Sir, my
4 was your father.
yes, my father
Is declared
thereafter
intimate
died.
right, title and interest. The private defendants are restrained from interfering with the peaceful possession. Yes, so Mr. Das's client's title was declared.
Lordship.
Yes. So on the basis of that, in the LA proceedings, award has been declared in his favor.
Ignoring the fact that the Order 9 Rule 13 is pending.
What is the stage of Order 9 Rule 13, Mr. Rai?
When Order 9 Rule 13, my lord, at the stage of hearing stage, my lord, they have been, my lord, they are appearing in that proceeding now. They are contesting.
Yes.
Well, I have missed, super my client
They are
says
contesting.
no such
And not
application is
only that,
pending.
yes, yes, they have filed a caveat.
Order 9 Rule 13 is pending.
They filed a
Wait,
caveat,
wait.
and not only that, a civil suit is another separate civil suit is also pending. DLR
For what?
civil suit for declaration of title, which was filed by us.
How can it be?
Already
Well, what happened? The Tara Prasanna was my father. Tara Prasanna's share.
What is the miscase number?
My lord, this Order 9 Rule 13 miscase number, my lord, is my lord, it is mentioned here, my lord. In the
Copy and
impugned
screenshot.
in the impugned order, it is mentioned.
Copy and screenshot.
In the impugned order, it has been mentioned.
Yes, yes. Because I filed documents to that extent.
37 of 2023. 37 of 2023. How it has been dealt with by the
In this impugned order. Yes,
Yes.
that's my lord. My lord, nothing has been stated. 37 of 2023. Information slip. Now kindly seize the decision with reasons.
Yes, Mr. Das. If
Internal page 8.
if,
Internal page 8.
a miscellaneous case is pending because that was an ex parte decree. On the basis of that ex parte decree, this order has been passed. Since the Order 9 Rule 13 is pending, how can you be allowed to take this money?
Not only that, my lord. My lord, we have.
My lord,
Yes.
Now, my lord, not only that, now Order 9 Rule 13 is pending. A separate civil suit is pending, which was filed by Sadon. My lord, initially Tara Prasanna filed the suit. Tara Prasanna died. Then Order 9 Rule 13 was filed by the legal heirs of Tara Prasanna. Now, my lord, Sadon filed a title suit that is pending, and my lord, my name was recorded in the LR record of rights. That was struck down behind my back, my lord, which was again restored. Thereafter, again, my lord, appeal is before, and that appeal is pending.
My lord, kindly
Another thing.
adjourn for it.
Yes.
Another aspect, my lord,
So
if
that means the
the
decree was taken into consideration while passing this order.
number kindly
That decree was ex parte. Order 9. Serious disputes with regard to the title between the parties.
But my lord,
This
it is
can-
an appellable
it has to
order.
be-
no.
What is an appellable order?
But a judgment and decree has been passed, my lord. How division is made to
No, not decree has been
What judgment and decree?
Judgment and decree has been passed by the earlier civil court. After reference, a judgment and decree has
His
been passed.
contention is
How is division
section
applicable?
3H4 is an appellable order. But I have authorities, several authorities to show
Show me.
that my lord, division is maintainable.
Not me.
Because since there is no
Under the Land Act 1.
yes, no, not Act 1.
Act 1.
NH, National Highways Authorities Act.
National Highways Authority.
26 subsection 2.
And my lord, before that, my lord, the order impugned, if your lordship sees, the court, my lord, was only interested with disbursing the amount to Manoj Bhattacharya.
Kindly say
My lord, if you
subsection
page for the
it is an appellable order, my deemed decree.
abhi dekhachhi judgment.
No, this is not an award passed by the against that.
And then 54, section 54 also.
Show me the award. This is not the award.
This is not the award.
This is not the award.
Yes, my lord. It is the award. It is
How
the
do you
award.
say this is the award?
Kindly see page 9. Our petition.
Reference made in such and such. This is not the award.
My lord, I am answering to that question also. My lord, I am answering to
After
that
that
question.
enhancement, this is
Kindly-
not the award.
My lord, the judgment and degree has been passed. It is never.
No, not a degree.
Where? Show me.
Yes.
Show me.
Order. This is an order. Under section 3H4.
This was under the land, National Highways Act.
Yes.
Show me, give me the National Highways Act.
Yes. Section 3H4. This point, my lord, came up for consideration before various honorable courts, my lord. I have a number of judgments. I shall place it here and now before your lordship. Whether revision will be maintainable, read will be maintainable, or 227 or 115. On all these points, my lord, I have judgments. Courts have consistently held, my lord, that since no appeal lies, my lord, the revision is maintainable. I shall place it. Before that, my lord, if your lordship goes to the impugned order also, your lordship will find that section 3H4, my lord, speaks about the apportionment of the entire share. The impugned order, my lord, speaks about only disbursement of the amount to Manoj Bhattacharya. And court says the rest amount of compensation be kept and be paid to whoever is entitled to.
That is the other one.
This is the manner of the disposal of the.
That is the other party, my lord, who did not put his signature in the power.
How biased it was.
My lord.
The question of maintainability, may I cite the judgments?
Yes, show me the judgments.
Not.
So Das, are you ready with this point of maintainability?
On this point, my lord, I have
may I first place, my lord?
on this point, I have to consult with some judgment.
This is a question of law, purely question of law. My lord, Mr. Das is, my lord, well equipped with, my lord, the question point of law. My lord, 2018 Supreme Online Kerala 37924. My lord, paragraph 3. Kindly see. My lord,
Yeah. When can you come back?
Yes.
No, next Monday, my lord. Coming Monday.
Yes. Call the next matter.
523, my lord. I was doing a matter in court number 8, my lord. It has been dismissed for.
Very junior, Mr. Banerjee. None of.
Sorry, my other side is here, my lord. Kindly, my lord. 523.
Please wait.
Lordship, I am applying by the petitioner, Lordship.
Yes.
Lordship, petitioner file an application under section 8 and 9 of the Land Reforms Act, praying for preemption right.
Yes.
Preempted.
Yes.
On the ground of adjoining riot as well as course error.
Yes.
Opposite party filed a written objection in the year of 2010. They specifically stating that the entire share was transferred, and another ground defense was that the suit property was never partition.
Suit property was
never partition. That means that they are admitted that I am the co-sharer. After 13 years, she filed an application for amendment of the written objection, incorporating the new plea that the opposite party was the borgadar under the vendor. That was allowed. That is the impugned order lawsuit.
Show me the original written
Yes, lawsuit.
objection.
Original written objection lawsuit, page 45. Page 45 lawsuit. And relevant part lawsuit, প্রকৃত বিবরণ, page 49 lawsuit.
Page
49. প্যারা 10 লসিপ, প্রকৃত বিবরণ এই যে অত্র মামলা আইনত চলতে পারে না, অত্র মামলার শাসন সাজনামা প্রতিপক্ষের নালিশি দাগে এন্টার শেয়ার নালিশি কৌলামূল্যে 1 নম্বর প্রতিপক্ষকে হস্তান্তর করে দেওয়ার অত্র মামলা ডিসমিস যোগ্য, দরখাস্ত করে নালিশি দাগে কোশেয়ারা বা আর্জনী রায়
49, yes, paragraph 10.
প্যারাগ্রাফ 10, দেন 11 পজিশন না থাকে অত্র মামলা ডিসমিস যোগ্য। thereafter লসিপ প্যারা 13, নালিশ সম্পত্তি কদাপি আপোষ অংশ বন্টন হয় নাই এবং দরখাস্তকারী আইনত অত্র মামলা করিতে পারে না।
He is the opposite party number 1.
He is the opposite party number 1 lawsuit.
Where is the amendment application?
Lawsuit amendment application lawsuit, page amendment of page 52 lawsuit. Only saying that দাখিলি করিবার কালে অধীন ডিউ বোনাফাইড মিস্টেক মূল আপত্তি কতক বিষয় উল্লেখ করিতে সক্ষম হয় নাই, সে কারণে প্রপার এন্ড কম্পেয়ার এডুকেশন নিম্নের তফসিল আপত্তি সংশোধন করা একান্ত আবশ্যক। Nothing was stated.
Sir, have you seen the amendment portion?
Yes.
Are you challenging this? Have you understood the implication of this amendment?
Yes, challenging the amendment application lawsuit, amendment order lawsuit.
That I have followed. I'm asking you, have you understood the amendment?
Yes, lawsuit.
Have you gone through the entire amendment? He is saying his Borga right has merged into his ownership right. How can he be the Borgadar now?
They claiming as a Borgada lordship by way of amendment.
You have not read the entire amendment. That's the problem. Yes.
The petitioner before Lord, petitioner before Lordship is a tenant in respect of a court on a very long.
Yes.
Acute problem. Excuse me, kindly.
Yes.
A suit for eviction was filed against my client on the ground of default and regional requirement.
So decreed.
Decreed.
You have preferred an appeal. Occupation charges. What is the occupation charges?
My rent was 1331. 15,000. 15,000.
What was the rent?
1331.
1331. What is the extent of your occupation?
Occupation 3 rooms.
Square feet.
Square feet, that is not available. Neither in the plane, nothing.
About
Where is the
1,000.
property?
Property at North Maniktola.
Maniktola Bazaar.
Not that one. Much interior, not Maniktola Bazaar, far away from Maniktola Bazaar. I am a poor tailor, having no means at all.
Landlords are poorer than tenants.
Normally, your lordship, my lord.
Landlords are poorer than
Not
tenants.
at all, not at all, my lord. I am telling your lordship, 4-story building. Only tenants are there in the ground floor. 3 upper floors are there, consisting of 14 rooms.
What materials you have produced?
I leave you, lordship. Kindly consider something. Reduce the amount to some extent. Kindly explain.
How much amount, according to you, is the reasonable amount?
I am ready to pay 12,000. 12,000.
12,000. Mr. Halda, what do you say?
In my written objection, I have claimed 25,000.
25,000.
He has not seek any leave to file any evidence in reply, controverting the said statement and or produced any rebuttal document in support of their contention that no, this is not the rental value of the said area. It would not be 25,000. It would be 5,000 or the else.
My lord, your lord.
950 square feet.
And they are complying that order.
My lord,
They are complying that order.
They're complying.
my lord, complying mean only the current. My lord, the occupation charges for the current month. My lord, otherwise, my lord, with my lord, extreme hardship, somehow
What is the stage of the appeal?
appeal stage, my lord. I think the court is lying vacant. Court is lying vacant.
Court is lying vacant.
My lord, it is my information. Your lordship kindly
Since when are you paying?
my lord,
Since when are you paying?
January.
2005.
January.
My
And what is the area?
Area
area
4 months.
4 months.
For 4 months.
4 months.
Yes. My lord, my lord, my lord, my lord, your lordship kindly have it.
The location, Mr. Rao.
My lord, location is very interior. And my lord, your lordship kindly see the condition of the building. Totally dilapidated and my lord,
So you will get a property at a lesser amount. Vacate. Why are you paying those? Don't take the trouble of paying 15,000. If you get in a similar locality,
my lord, I am not going to all this controversy. But I am beseeching you, lordship, kindly consider.
I think, Mr. Rao, that was the first question which you have put to your client. What would be the market rate in the same locality? This
My lord,
application,
my lord, then your lordship kindly consider one thing. So far area is concerned. My lord, up to my lord, so far current occupation charges I have been up
yes,
to date.
4 months, 60,000.
My lord, 60,000 is very difficult. I am telling your lordship.
I'll give you some installments, pay that within some.
All right, my lord.
Because the court is lying vacant, Mr. Haldar, you cannot also get the appeal hard in the meantime.
Yes.
So, November, by the end of November, you pay off the areas.
Deeply obliged.
This application under
Complainant before the West Bengal Real Estate Regulatory Authority is the petitioner before your lordship. Not the proceeding initiated since I have paid in respect of one self-contained flat.
What do you want?
Not for there is a direction by the competent authority that yes, I will have to hand over the respondent has to hand over the possession of the flat and for necessary registration to be done, including 2 car parking. Thereafter, that order was not obeyed. Before that forum itself, the proceeding.
Purchaser.
I am the purchaser, complainant. Before that forum itself, the execution is not proceeded with. Kindly see the last but one order, 7th of March 2024.
Yes.
They appeared in that proceeding, in the execution proceeding. And kindly see, after hearing both parties, the authority is pleased to give the following direction. Your lordship got it?
Yes.
Kindly see, A, B, C, D, these are the order.
Yes.
And further hearing, the posted for 9th of July 2024. 9th of July, kindly see.
Yes.
After hearing the last portion, after hearing the complainant and after going through the document placed on record, the authority is hereby pleased to direct the following. The director of the respondent company such and such is hereby directed to appear in person before the authority on the next date of hearing.
What happened after that?
Nothing. Even no date is being posted since then.
So I'm directing these proceedings to be disposed of.
Yes. Kindly do. But
this is the execution proceedings.
In connection with the usual.
No separate number is.
No. Even it proceeded on the same number.
This application under Article 227 of the Constitution. This matter.
Item number 1353.
My lord, 1353, I am reading on behalf of the petitioner, my lord. I am receiving the affidavit of service, my lord.
Affidavit of service.
Service.
Time for the 20 boxes.
Yes. Yes.
My lord, the respondent plaintiff filed a title suit before the learned additional judge.
Yes,
Senior judge.
Why are you not allowing them?
Senior division Bakura.
Construction.
There was
just propped up. As per the as per the my plaintiff, if your lordship kindly
It's a partial suit.
shoot for partition. Now
He's a co-sharer.
he is a co-sharer.
You have your house.
My lord, that is the reason, my lord.
You have your house.
My lord, here, my lord, the petitioner, the my lord, plaintiff over here, my lord, as the opposite parties, my lord, she purchased a certain portions of the my lord, land in respect of plot number 582. Now, my lord, in that portion, my lord, I filed a suit for my lord declaration declaring my lord right to the effect of my lord 5 decimals of land. My lord, now this second part is this, my lord, there is a Bata plot 582/15 something, my lord.
Yes.
My lord, now on that, my lord, I have claimed for partition, which I have inherited from my predecessors.
Yes.
My lord,
And
now
he is a co-sharer,
in respect of that, my lord,
that butter plot.
Bata plot.
Yes.
Now, my lord,
So he wants to construct on that butter plot.
Bata plot he wants to construct, my lord, but
What is the difficulty?
my lord,
Within his share,
within his, not within his share, my lord, it's a common, my lord, we have a
No.
common.
to the extent of his share. Common, everyone has a right.
The entire building, my lord, there is a old building. My lord, the old building, everyone has a equal share, my lord. Now he
Yes.
wants to, my lord, develop into a two-storied building. But that is the difficulty. How can it be, my lord?
My lord, the house of the petitioner is
Commissioner's
So it
report.
says that he wants to complete the unfinished construction.
Yes,
my
in
only
respect-
flyover,
my lord, first floor.
first floor.
Some construction has been made.
My lord, first floor, my lord, now, my lord, we are also using the, my lord, ground floor. Ground floor portion, my lord, we have a right.
Yes.
My lord, now, my lord, he is.
So without claiming any right, because he has unfinished, where is the any commission made?
Yes.
Yes, commission.
Show me what
Two
is the
times,
extent
my
of-
lord, commission has been made, my lord.
Show me the extent of
Yes,
construction. Show me the commission work. Report of the commissioner.
My lord, page 50.
Page
50.
Yes.
Yes. 45, my lord. Commission's report. Annexer F,
Page
45.
No, what is page 50?
50 is the field note.
Field note.
Field note. 45 is the report.
Yes,
Yes.
45 is the report.
Kindly call
The, which page states that what is the nature
Yes,
of the
yes, I'm
46, my lord. Column 2, paragraph 2,
ceiling level?
ceiling level.
ceiling.
Everything has been made.
Yes, my lord.
Complete without claiming any equity.
Yes, my lord.
My lord, my lord, now we are using the, my lord, then, my lord, kindly.
You are using where?
The same property, my lord.
Mr. Ganguly, what happened? He has made the construction. So that was constructed up to the ceiling level.
Yes.
Centering completed, everything done.
Yes, my lord.
Construction of the roof of the first floor of the dependent numbers one's house.
Then
Construction, heap of sand, showed me a window like construction towards 3 windows. Everything is done.
and the contrary is a complaint. There is some.
I will make it clear that he cannot claim any equity.
My lord.
If you succeed,
Yes.
shares he will be getting.
According to suit, my lord.
My lord.
Let's call the next
Second
matter.
number 1329.
My lord, item number 1329, I am for the petitioners, my lord. This is my affidavit of service. My lord, by the impugned order, the application under Order 6, Rule 17, filed by the defendants opposite parties, my lord, in my ejectment suit, where they had sought for amendment of their written statement, along with introducing a counterclaim, was allowed. And this application under Order 6, Rule 17, my lord, it was filed after framing of issues. Whether, my lord, counterclaim can be filed after framing of issues, my lord, that is my contention, my lord. Because
Counterclaim cannot be filed after
framing of issues, my lord. I am with some judgments of the Honorable Supreme Court on this point, my lord. That is my limited grievance, my lord, in respect of the impugned order, my lord.
Have you got the recent judgment of the Honorable Supreme Court?
My lord, I have the judgment of Ashok.
Judgment of the Honorable Supreme Court.
Ashok Kumar Kalra versus.
Yes.
Yes.
The observation by Justice Shantana Godar.
Yes, my lord, but two judges had, my lord, laid down some guidelines, my lord.
Yes, after that, an exception has been carved out by the third judge in that judgment.
My lord, but there's another judgment I'm also relying upon, my lord.
This is the three judges being judgment considering all.
My lord, but two judges had ruled, my lord, they had laid down certain exhaustive guidelines, my lord, where,
yes,
my lord, kindly comes to page 16, paragraph 20.
Only the issues have been framed.
Issues were framed after framing of issues, my lord. The application under Order 6
is a separate judgment. Yes, in the SCC version, it's a downloaded version.
Yes, my lord. It is a download.
So, you can come straight away to
page 17, my lord. The guidelines have been laid down over there.
Yes.
আরেকটা আছে যখন
paragraph 23 of the judgment, middle paragraph. So evidence has not started.
Evidence has not started, my lord, but
kindly come to paragraph 20, page 23, middle paragraph at the same time in exceptional circumstances.
my lord, but another judgment of
Even after framing of the issue so long as the court has not started.
my lord,
because
another judgment, a recent judgment,
because there is
another judgment, a recent judgment of 2022, my lord, where, my lord, the guidelines of Ashok Kumar Galra, my lord, have been followed, my lord. Kindly seize.
It has been said that after framing of issues, this cannot be done.
My lord, yes, that observation is there, my lord. I'm just coming to it. Kindly comes to, my lord, page 12, 14.1, paragraph 14.1.
Yes.
In the totality of the facts and circumstances of the present case, we are clearly of the view that neither the requirements of Order 8, Rule 6A or Rule 95 of the rules, nor the principles enunciated and explained in Ashok Kumar Kalra operate as a bar over the prayer of the appellant for taking the belatedly filed counterclaim on record, which was indeed filed before framing of issues. And my lord, also,
so it has not
paragraph 13 of
Order 8, Rule 6A or the Rules 95 does not
also,
that.
Also, my lord, paragraph 13, my lord.
Yes.
Paragraph 13, page 10. May I read, my lord?
In Ashok Kumar Kalra, the three-judge bench of this court,
13.
13, page 10. In Ashok Kumar Kalra, the three-judge bench of this court essentially considered the question on reference as to whether it is mandatory for a counterclaim of the defendant to be filed along with the written statement. While answering this question, the court underscored the basic principle that procedural law should not be construed in such a way that it would leave the court helpless, and that a wide discretion had been given to the civil court regarding the procedural elements of the suit. Having said so, this court observed that a counterclaim is designed to avoid
Sir,
multiplicity
only
of...
one thing.
Yes,
What is the object? It can be filed till the issues are framed.
Till the issues are framed, my lord.
So here, in a case where only issues are framed, but evidence has not started, what's the
but the
so no difficulty.
Guideline is, my lord, that
Yes, guidelines, it says it can be,
my lord, kindly sees the last observation, my lord, kindly, my lord. However, the majority opinion has been that the defendant cannot be permitted to file counterclaim after issues are framed and the suit has proceeded substantially. After issues are framed.
Has proceeded substantially. It has not proceeded substantially.
My lord, but the observation of the majority of the two judges was in any event, it cannot be filed after framing of issues. In any event. My lord, kindly sees that observation, my lord. My lord, kindly sees in Ashok Kumar
Paragraph 13, it says, after the majority opinion has been that the defendant cannot be permitted to file after the issues are framed and the suit has proceeded substantially. Here, a suit has not proceeded substantially.
My lord, but in Ashok Kumar Kalra, two judges of, and it has also been followed by a coordinate bench, my lord, where the application under Order 6, Rule 17, the amendment was allowed, but the counterclaim was rejected by a coordinate bench, my lord, following Ashok Kumar Kalra. May I just place that judgment, my lord, for my satisfaction, my
If you want to make it a comprehensive argument, I can fix it after the vacations.
My lord, I leave it up to your lordship.
Yes, what do you say?
My lord, I was also relying upon Ashok Kumar Kalra's the exception part and relying upon Ashok Kumar Kalra coordinate bench judgment, which allows, my lord. My lord, that is my copy, that is marked, my lord. May I place the fresh copy? The fresh copy, I want to mark for us. Lord,
Cause of action part, there is no difficulty. It is prior to filing of the written statement.
At the filing of issues, my only
So your only objection
contention is
it
that
cannot be filed after framing of the
framing of issues. I have nothing to say with regard to what amendments are sought to be incorporated, only with the introduction of the counterclaim.
Page 6, paragraph 15 of the judgment.
So here also, after the framing of issues, it was filed. Show
And-
me that fact.
Well, paragraph 15 kindly sees it discusses the law, and the fact is at well, page 5, paragraph 13. Question whether a counterclaim can be filed at any time, even after filing of the written statement in no more recent. Well, this has been held because and with regard to the facts of this case, well, paragraph 2, page 2. The points it has been pointed out, my lord, A, B, and C, my lord, takes.
My lord, kindly sees the judgment which I placed, my lord, passed by the coordinate bench over there, my lord. Also, it deals with whether it can be filed after framing of issues. My lord, kindly sees page 3, paragraph 7. May I read, my lord?
Page 3,
paragraph 7. However, the rival contentions of the parties, although Mr. Ghoshal relies on a decision of the Honorable Apex Court in the matter of Mahendra Kumar and another versus State of Madhya Pradesh and others, reported in AIR 1987 SC 1395, this court is of the view that filing of a counterclaim after the issues have been framed cannot be allowed. The proposition laid by the Honorable
paragraph you are placing?
My lord,
page 3 and 4.
Page 3, paragraph 7. That is the judgment passed in Mohan Bhattacharjee versus Shivani Bhattacharjee.
Page 3,
Paragraph 7.
Yes.
May I read
that filing of a counterclaim after the issues is
The court is of the view that filing of a counterclaim after the issues have been framed cannot be allowed. The proposition laid down by the Honorable Apex Court in Mahendra Kumar is that counterclaim need not be filed along with written statement. The same can be filed after written statement had been filed. However, the law is that a counterclaim, even if
You have 87 Supreme Court 1395.
no, my lord, that I do not have with me right now. And my lord, in this case, the honorable,
With a 3-judge bench judgment or a 2-judge bench judgment.
my lord, I do not have that right now with me.
Then it's to be referred. This point is to be referred.
Yes, my lord, let it be referred, my lord. And over here, my lord, the coordinate bench had rejected their application for the counterclaim which was incorporated in the written statement, but allowed the amendments. Kindly sees, my lord, page 9, paragraph 10.
But with regard to the question posed by your
Kindly sees, my lord,
Please give me a minute.
page 9, paragraphs 10 and 11.
Give me a minute.
Judgment.
So in this case, amendment was allowed.
Amendment was allowed, but the counterclaim was rejected.
This amendment application was filed at the stage of fag end of the.
That has not been mentioned, my lord, but
This paragraph 6.
my lord, but the proposition I'm relying upon, my lord, whether counterclaim need not.
Proposition has to be on facts.
My lord, but over here, my lord, what is my respectful submission? It is written, my lord, the same can be filed after written statement had been filed. However, the law is that counterclaim, even after the filing of written statement, must be before the issues are framed, my lord. Page 4, my lord. And
don't you have this Ashok Kumar Kalra's SCC version?
My lord, I have, my lord, the translated version, my lord, the query with regard to Mahendra Kumar, my lord, Ashok Kumar Kalra dealt with Mahendra Kumar.
And my lord,
yes,
this was
it has dealt
87
with,
Supreme Court was
my
dealt
lord,
with
dealt
this
with.
paragraph.
My lord,
That
in
is
my
what I-
judgment, may I hand over? It is paragraph, my lord, 14. In my copy, my lord, may I hand over my
paragraph
14?
Yes, yes. 87 3 SCC.
My lord, that has been dealt. And not
This
only that,
application-
after Mahendra Kumar, Ashok Kalra, another judgment which I had handed over, my lord, the coordinate bench, my lord, that has also followed this Kalra, my lord. That is Mahesh Govindji Trivedi versus Bokul paragraph 14 of the coordinate bench judgment I handed over. This also deals with this, paragraph 14. I have handed
Judgment
of these, my lord, just
Prahlad Roy versus Ashit Roy.
my lord, in that paragraph 14 deals with another judgment which relies on Ashok Kumar Kalra to hold that in exceptional cases it can be extended.
Supreme Court has made it clear in Ashok Kumar
This is
Kalra.
also Supreme Court that is
That has
relying
been
upon
made
Kalra.
clear.
Paragraph 14, another judgment is quoting Kalra to say that it can be extended.
The application under Article 227
Item 1311,
And I'm for the petitioner, my lord, Mr. Chaudhary is here. I'll pay for not this week, my lord.
Will go down, madam. Will go down.
My lord, next week, my lord, any day, Mr. Chaudhary is not in court,
An
my lord.
accommodation has been paid for on the ground of the learned senior. Yes. This matter was mentioned citing our yes,
But I am for the petitioner in this matter.
yes.
But I am the plaintiff in a suit for blood recovery of possession. But I got a blood.
The impugned order.
But the impugned order is I took out an application under 151 relying upon a judgment of this honorable
Where
court.
is the opposite party, Mr. Mukherjee?
But Mr. Doctor has served, Lord, I am told.
Prior to upgradation, who is appearing?
Swapna, Nicher Court advocate.
Some David.
He has served the learned advocate appearing in the court below. And on the last occasion, কেউ appear
Below,
করেছে?
no one has entered appear.
Appear করেছিল এখানে?
Copy সার্ভ করেছি, নোটিশ সার্ভ করেছি।
Yes, yes, what is this matter?
No, but, I took out an application, but there was initially not a decree in this. I get dismissed. It was not remanded by the first appeal court.
Who are you?
I am the plaintiff in a suit for recovery of possession.
You got a decree.
No, not the decree was
Suit
refused,
dismissed.
and I went up in appeal. In the appeal
Remanded.
court, it remanded with a prayer, Lord, that I can take out an application for amendment of the plaint, Lord, to Lord cover up, Lord, the latches. So, Lord, I filed a amended plaint. I got the plaint amended. I took out an application in course of Lord, the suit after remand under section 151, relying upon a judgment of this honorable court that during the pendency of the suit, I should be compensated with a mean profit or an occupational charges. But this I said because the other side was occupying and the suit was of the year 2008.
Suit under what provision?
But this is now after the amendment under 2G. After amendment, Lord, and in the amended plaint, I have prayed from Lord the mean profit.
Initially, it was a suit under section 6.
Yes. For the reasonable requirement and default. Thereafter, it was amended and 2G has been brought. Okay, Justice Shampa Sarkar judgment. I rely upon a judgment, and based on this judgment, the application was taken. The
I
learned
have delivered a judgment under the Premises Tenancy Act suit. You are not entitled to mean profit during the pendency of the suit.
This is Lord, running contrary to Lord, this judgment. Lord, I do not know when your lordship has passed the judgment, but this one, Lord, your lordship will kindly have a look at that.
This is relying upon the Supreme Court judgments.
Lordship. And Lord, kindly
Considered
come
those.
to page.
Have considered those judgments. Because in the Supreme Court judgment, Mr. Mukherjee,
My lord.
no final decision was passed. Points were referred to. Occupation charges was not directed to be paid to the other side. It was directed to be deposited with the registry of the opposite Supreme Court. And that application was kept pending. Issue till not decided. In the,
But here also, my lord, if your lordship says that, my lord, the amount is to be deposited, a
that
person
is a
cannot,
different
my lord,
thing.
enjoy a property without paying anything.
Issue was decided that they are entitled to. Even that was a suit under the Transfer of Property Act after the expiry of lease, even in such a suit.
My lord will kindly consider paragraph 21 to 24.
Even Mr. Mukherjee, there are two things. Even if under 2G, it remains a suit under the West Bengal Premises Tenancy Act 1997.
True. But only, my lord, I'm not to prove any of the grounds under 6.
You are relieved from that, but it still remains a suit under the Premises Tenancy Act. So there's a distinction. So,
but this
you
was
must have made those decisions because I have considered all those decisions.
But I'll go through my lord's judgment. Not certainly
And,
I will go through. But not even if your lordship
It might
thinks
be a different thing, but there I have considered the issue of statutory tenancy and the provisions of Section 7. The effect of that, you cannot compel a person to pay more than that. That's the only compliance and if he complies with that, he is safe from a decree for eviction. He's protected.
lordship. But I'll also not come up with a judgment a few days back before the division bench of Justice Arijit Banerjee. I lost in one of the matter that where my lord, Order 39 Rule 10 was my lord, applied for asking a deposit of the admitted rent. Order 39 Rule 10. Not very.
Admitted rent, Mr. Mukherjee, in a case under the West Bengal Premises Tenancy Act, unless you pay that amount, your defense will be struck off.
It was a question of deposit of that amount before the registrar during the pendency of the suit.
There is no question of depositing before the registrar because under the Premises Tenancy Act, Section 7, you have to comply with that. You have to deposit in court.
That is not a statutory obligation.
Yes.
But beyond the statutory obligation, there are certain equitable jurisdictions being entertained.
It's difficult. Then, Mr. Mukherjee, this Section 7 goes.
No, Section 7 will apply in the stages. At that stage, if there is a question of default. Now,
even if there is no question of default,
lordship,
once a notice is being issued, that contractual tenancy becomes a statutory tenant. So he is only to comply with the provisions of Section 7. If he does so, he is safe from that. Otherwise, the benefit now, if you say yes, let us take a hypothetical case, yes, an order is passed. He does not comply with that. What will be consequence? The defense will be struck off. An order is passed without any consequence. What will be the effect of that? You cannot strike out the defense. No decree for eviction also can be passed for non-compliance of that. Then I've considered all these. I've considered all these provisions and I've.
If your lordship asks me the view that what your lordship has taken will be my view. But now, Lord, the equitable jurisdictions are taken by the honorable
equitable, yes.
This is not a Mr.
Mukherjee.
The simple reason that somebody is enjoying a property without payment and therefore you have to pay.
Yes. Can be under the Transfer of Property Act, expiry of lease, you can say so. Expiry of lease, other things.
Even in
but if in a Premises Tenancy Act, difficult. Because protection, special protection to the tenants is being conferred by that statute. If that is so, and upon compliance, he gets a protection. Can you take out that protection?
That I cannot. But Lord, once it falls in the domain of 2G, Lord, then Section 7 doesn't apply.
Yes, that's the
that is in those cases, Lord, I can always come up with this.
That is one distinction which you can make out. But
6 and 7, Lord, it doesn't apply in a 2G case.
Yes.
Then, Lord, whether Lord, Order 39 Rule 10 can be resorted to in case of an admitted Lord rental amount. Kindly, Lord, visualize one thing. Lord, a particular tenant is Lord occupying a property without paying any rent. Now, Lord, there is always an element of a commercial aspect in renting a property.
There are two aspects of the matter. Let us assume in such a suit, let us take out 2G for the purpose of consideration now. Now, if that suit is dismissed, let us assume a Premises Tenancy Act, default, reasonable requirement. Yes, according to you, yes, since he is occupying, he has to pay the current occupation charges. Even if it is accepted, but your suit ultimately gets dismissed. then
I don't get, my lord, the recovery of possession of the property, but the money, my lord, that is
difficult because now again after dismissal contractual tenancy
yes, and that will be adjusted.
it gets revived. So he will be a tenant at that contractual rate,
Yes.
not at this.
Yes, but
So whether you are entitled to any higher amount or not, unless a decree is passed, it's difficult.
but that has been taken care of in this judgment to say that in the event of, my lord, my unsuccessful, my lord, in the suit, my lord, the amount that is deposited will be adjusted.
Mr. Mukherjee, I have read that decision.
Lordship.
Has kept that point open to be decided at the final hearing. It was in a SLP stage on 3 interlocutory applications. Those whether order was passed, reports were called for, parties did not object to the rate of occupation charges, or Supreme Court did not direct payment to them, directed to be
That is a
deposited
deposit.
with
Lord,
the
Lord,
registry and kept that issue open to be decided. Till now, I am told not decided.
Lordship.
So there is no ratio till now decided that in a pending suit, it has to be done. The Honorable Supreme Court has till now not decided that issue.
Lordship.
And that was a suit under the Transfer of Property Act, expiry of lease. That is a much better
No,
case.
that is, I agree, my lord.
Expiry of lease,
is
you
a
can
much better.
say, you can also claim mean profits from that date.
Yes.
But it's difficult to claim mean profits from that, from the date of issuance of section 6(4) notice or 13(6) notice with effect from that date.
Lordship.
It's a difficult thing. Unless a decree is passed, statutory tenancy continues at that rate, not at any higher rate.
Lordship.
Order 39 rule.
Lord, I think that's 10, Lord. I'll just, I think.
This is a different thing altogether, Mr. Mukherjee.
But again, this is a deposit. This is all about, Lord, the provision concerning deposit. I say that. It is not about that, Lord, I can lay my hands on the money.
Yes, what is the impugned order?
But the impugned order says that the question that I have raised in the 151 application, that is a triable issue and it has to be gone in the trial. Lord, kindly have a look at page
What is
11
the
of my
stage of the
application.
suit?
Roger, that is stage আছে না? Huh.
It seems that you are not interested in a decree. You are interested in money.
No, Lord,
You are not interested in
my
possession.
advice was otherwise. I said that I need a expeditious disposal of the suit rather than money. But we are creatures of instruction.
If you want this point to be decided, then
my lord,
it has to be kept pending, Mr.
and
Mukherjee.
Lord, in all probability, a reference will ensue. Because your lordship has, Lord, given a different opinion in another judgment. And Lord, the judgment that I cite has a different.
2G.
The suit that was
This is in 2G.
My suit is in 2G.
No. The decision which you have handed up.
No, my lord, this is not in 2G.
This is
not in 2G.
This is in what?
Lord, this was in respect of, Lord, it was in the recovery of possession, my lord.
Not under section 6 suit.
Not under 6.
That is a different thing altogether.
Not
So
under
I have decided on section 6.
No, section 6.
Khaitan Consultants. In Khaitan Consultants matter, I have delivered.
No, my lord, this is, my lord.
So this is
not a
under
section 6.
No, I have decided in a suit under the Premises Tenancy Act. I have considered those provisions.
Lord.
And
But
I
that
have
was
said-
in the context of 2G or, my lord, 6.
No, not 2G.
Not 6.
6.
So, my lord, 6, my lord, I will not be even arguing this because, my lord, I know, my lord, the 6, it will be very difficult because 7 is there either before the court or before the rent controller.
Yes. No, after 6, you have to be in the court. not
Be in the
before
court. And before that, it is before the rent controller. So, my lord, the question of deposit at that point of time is, my lord, it is statutory. But, my lord, if it is not covered by section 7 or 6, in a question of default, then whether your lordship can, my lord, direct deposit under order 39 rule 10 or not, being the only statutory
What
provision.
took place?
Lord, that
Yeah.
is death.
Death of the original tenant.
But yes, I'll give you lordship, Lord.
Prior to 97 Act or
6 February 1997. 1997. 1993. Then new judgment. No applicant, not applicant. But I know, Lord, this is the problem that has been created by the trial court. Gave up, Lord, the question of reasonable requirement in the amended plain, Lord, reasonable requirement has been brought in.
Now you are gone.
Question of default has been, Lord, taken. A
Mr.
new
Mukherjee,
Supreme
please
Court
back up.
judgment, Lord, it reverts to the position of 2H.
So
After
they are
Nasima Naki.
So in this matter also, given the pendency, it will be difficult for you.
Very difficult. But Lord, one saving grace is
Advice,
there.
Mr. Mukherjee, since you are there, advise your
But
client.
there's one saving grace. Not although they have taken the point of 2G, but they have not given up entirely the
That's
point of
the reason.
reasonable requirement.
So
The reasonable requirement is accepted.
if that is your case, then occupation charges pending suit is not.
Look, I understand that. Lord, because there is also a question of default that has been taken, Lord, even in the amended suit. Even in the amended suit.
So,
Lord, I would, Lord, subject
and
to
they are
what
complying with
instruction I
section
give.
7. They are complying with
No,
section-
they have not.
defense struck off.
No order have been passed, Lord, under 7.1.
No.
There is no requirement of 7.1 order.
No. Prior to that, when the suit was continuing,
no, nothing. They say that they are not in default.
They are not in default. But after remand,
nothing has.
They are complying with this deposit.
There was no 7.1 deposit at all. But it equally true, I did not, Lord, in my plain disclose how much is the default amount and the amount of rent.
Mr. Mukherjee, there are two things. One, you may not take the ground of default.
I have taken the ground of default.
You may not have. In a given case, you may not have filed a suit on the ground of default. You may have filed a suit on other grounds. Even then, after filing, no landlord will accept. So it's the rarest of rare case after the filing of the suit, the landlord will accept. So compliance of section 7 is in a suit on any of the grounds under section 6, not only on the ground of default.
Yes.
So they have to comply with section 7.
But the difficulty, I tell you, Lordship, in the plaint, I have not stated how much is the actual rent.
What do you want now?
But I would rather request not that your Lordship passes an order for expeditious disposal of the suit. It started in 2008. But instead of going by, Lord, the amount.
What shall I record with this?
Kindly record my submission that, Lord, I have prayed for, Lord, expeditious disposal of this suit.
This application under Article 227 of the Constitution of India.
Lord, the Supreme Court's advice, Lord.
Mr.
This
Under
was
certain
12
exception,
years, Lord, it started in
That's
2000.
why I have couched it in a different way, keeping in mind the date of filing of the suit.
Lord.
That's the.
I understand, Lord, now the
Because
impediment
now-
that has come.
And the other thing, you do not know the number of these expeditious hearing applications which are being filed. Immediately after filing of the suit, issue summons, expeditious hearing.
Now what is,
Application.
Lord, yes, I.
The judicial, they are under tremendous pressure also.
But this was not an
And will
appropriate.
come that no matter in usual course will be taken up. I'm telling you.
I'm grateful.
Yes. Call the next matter.
Item number 1520.
Yes. Yes.
My lord,
Yes, yes.
kindly have a look into the impugned order.
Yes.
The direction was made for to visit the child.
Yes.
But my lord,
So Dholapati, this was another contested application.
why?
Yes. 18th of February 2025.
Okay. Oh, everybody services. Sorry, my lord.
Yes, next.
My lord, directed to appear the matter.
Contested application because there was a direction to appear under the
Number 414.
414. Yes.
Sorry, my lord.
414, I appear on behalf of the private respondent.
Private?
Respondent, my lord.
There is no private respondent in a
The opposite party, my lord. I have not been served, my lord, but I have been told that there's an appeal.
not
There's
been
a
served.
not been served with the application, my lord. Kindly dismiss the because there's a proceeding, my lord. Let me kindly give
None
me
appears. This matter was mentioned citing.
I am for the petitioner, Your Lordship. Your Lordship, a partition suit of 2006, Your Lordship. The
Yes.
petitioner is a 61-year-old lady, Your
Yes,
Lordship.
hearing.
Your Lordship, earlier an order was passed, which is at page 137, Your Lordship. Your Lordship, an order was passed on 8th November 2019 at page 137. However, Your Lordship, because of COVID, no progress could take place, Your Lordship.
I have instruction to appear on behalf of opposite party number 19.
To delay the matter. All right.
Why
You are also consenting to the expeditious hearing. This application under Article 2.
Your Lordship, one more thing I wanted to submit. Your Lordship, the trial has not commenced. Even interim application has not been disposed of.
Interim applications are pending.
Pending, Your Lordship. And Your Lordship, one more thing, Your Lordship. I am a heart patient, Your Lordship. For treatment, I need money. I made an application under Section 52. Your Lordship, that may be disposed of first, Your Lordship.
There are certain
That is
substitution
an
applications also pending.
All applications. This application under Article. Yes. Yes, Mr. Banerjee, do you know any junior of Mr. Kaustubh Chandra Das?
আমি নেই তো ভয় লাগে
Do you know anyone, his friend, any? Know the office? Who will be there in the office?
100% বললাম
His office is at 10 Old Post Office Street. Ashun.
Seven.
127, I appear for the petitioner, Your Lordship. This is an application for expeditious sharing of matter.
Of what?
Of miscase, Your Lordship.
What is the miscase for?
Miscase is.
Under what provision miscase?
Your Lordship, it's a. It's partition suit mainly. Title suit was filed. Thereafter, the opposite party filed the miscase, and it is still pending, but no such. Kindly see.
This application under Article 227 of the Constitution of India.
I'm the plaintiff petitioner before your lordship filed a suit for declaration and injunction. In that suit, my lord, I filed an application for repair. In repair application, my lord, and local.
But the plaintiff.
I am the plaintiff in a
declaration of tenancy right.
Tenancy right. Now, in that suit, my lord,
declaring application rejected.
My rejected only on the ground that the estimated cost has not been mentioned.
No, no eviction suit has yet been filed.
Eviction suit has been filed, that is pending.
Writing the eviction suit.
I know, my lord. But before that, kindly turn to page 20, page 20.
Yes.
But that's why, my lord, Justice Sarkar was pleased to fix the matter at 10:30, but unfortunately, matter did not.
Releasing this matter.
Kindly see page 20.
Yes.
The commissioner's report. I want to repair the tin shed, my lord, and the two bamboo. Now, my page 20, your lordship will find that in presence of the my lord, learned advocate, the commissioner went there. My applicant has been turned down. Only I have not given the estimated cost. Only for that reason that.
Yes, you are opposing.
But I am opposing the prayer.
Yes.
Lord, my application, Lord, his application, Lord, the kindly see this
He
application.
will repair at his own cost. He will repair at his own
Without
cost.
claiming any equity.
Not only the repairing, Lord, the kindly see, he is trying to, Lord, the erect the new structure over there.
Not my lord,
Lord,
kindly.
the
No
kindly see-
existence of any structure.
No, my lord, not that.
Yes, kindly see.
Ma'am, may I
Lord,
just-
Where is the report of the,
May I just
Lord,
show the report, my
is
lord, of the
here,
commissioner?
21.
May I show the report of the commissioner and the prayer for repair? Whether the tin shed of the food factory premises has been damaged or broken, as we will see from the naked eyes. The food factory consists of 2 rooms. Both the rooms have tin shed. My have your lordship got it.
no, it was not rejected on that ground. It was only rejected on the ground that the
Not-
estimate was not.
Kindly send back.
That is true, Lord, but the kindly see
Kindly
the
send back
application.
to side.
Lord,
If you want that, I can remand this holding that is not necessary. The learned trial judge will consider, or I can allow him to undertake the repairs according to your own choice.
then Lord, remand this matter for fresh consideration.
Within certain time, because my since my lord, long time, my lord,
This application under Article 227 of the Constitution of Yes,
Of the defendant's application
yes.
suit for declaration of title and perpetual injunction. In course of pendency of the suit, parties arrived at a settlement. The plaintiff took money from the.
Then why are you troubling the court?
I don't have any other option.
Only one thing.
Don't have any other option. I filed terms of settlement along with my learned friend filed order 23 application. Matter was sent to mediation. Mediator submitted a report saying that matter has been settled. Till the learned trial court with all respect is not allowing the plaintiff to withdraw the suit.
This application is pending.
You want to withdraw your suit?
Recording the terms of settlement, I wish to withdraw.
I'm the
Recording.
defendant.
So cannot withdraw. So the terms has to be recorded. So order
Yes, but that
decree on that terms has to be passed.
But that decree is to be passed.
Order 23 rule 3. I'm directing that to be dismissed off.
Within a week, my lord will kindly
Sometimes,
do. These kind of directions these directions were passed repeatedly. The learned judge is not taking up the matter, and I being a defendant,
Have some sympathy for the judicial officers.
I wish my lord were there. I
One week it's difficult, Mr. Banerjee. I do not.
my learned junior has fast and experience.
What is the next date fixed?
এটা পুজোর পরে বোধহয়।
order 23 filed on 17/10.
What is the order?
Date board?
Milord, there is no answer. Prayer is, Milord, with regard to this disposal of this order 22 rule 3. Disposal of this order 22 rule 3. Milord, which
Order 22 rule 3 or order
23 rule.
Yes.
Now,
And
Milord,
this is pending since November
24.
2023.
24.
23.
What is the next date fixed?
My learned junior will immediately.
Online it shows.
What are these orders which are under challenge 2nd of August, 11th of
These are
September?
all orders postponing the dates. And my lord was kind enough to issue a direction for arrival of the trial court records. Kindly see the previous directions passed by your lordship. My lord will kindly pass an order under order 23 here. My lord has that jurisdiction. 29th December is the next date. And because of our past experience, we know for sure a put up petition will be of no use there.
Peremptory direction. Let it there be a peremptory.
Peremptory হয়েছে আগে কিছুই হয় না।
January 29
So the previous date was 29th of January, then this was shifted to 29th of December. And for this purpose only. Can you have a look at my lord's last order passed on 21st of February?
I did not call for the records.
Called for earlier? Yes, yes.
That is why I was astonished.
Yes, yes. But this was the reason why
You have
records.
told me I have called for the records. That is why.
My lord,
I have only directed implementation of the earlier order. I have not called for the
my lord,
records.
sir,
That is why I was searching.
Oh, what? I stand corrected. But there was a follow-up order, if I may put it in that way, by your lordship. Kindly, rescue us from this litigation here only.
This application under Article 227 of the Constitution যেটা dismissed for default. Where is Mr. Banerjee?
Lordship, so item number 762, Lordship, I beg my sincere apologies. I could not come at the time of call, Lordship.
Yes.
Lordship, I have been instructed to appear on behalf of the petitioner, Lordship.
Yes.
I don't know, 762, it was.
What has been done?
It has called 762.
762 has been called now.
Yes, we might have 762.
762.
Yeah, where Mr. Das was previously there.
Oh, now you are appearing.
I am appearing, Lordship. I beg my
Oh,
sincere.
তাহলে ওইটা 762 যেটা বলো না
I have already filed my
administrative
call.
notice এর ওই অর্ডারটা কেটে দিয়ে লিখুন Mr. such and such learned advocate appears and submits. Have you filed the Pakalatama?
I already filed. I was at court 35, could not confirm.
All right. Are you ready?
I'm ready. I'm ready.
Submits that Mr. such and such learned advocate appears and submits that he has instructions to appear on behalf of the
I have
petitioner.
served notice
He
to
has
the other
also-
side as well. For
Who is
upgradation.
appearing for the?
Other side, Mr.
Yes, he further submits that he has already filed the Pakalatama. Stop. Let the matter retain its position in the list. ঠিক আছে?
Lordship, I have served notice on 30th July to Mr. Abu Musa.
All right, I'm retaining that matter in the list. Let the matter.
Grateful, Lordship. Grateful.
Yes, 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 Mr. Banerjee, which matter?
523, Lord. 523, Lord. I'm sorry, Lord. I was.
You have a
And one under 7C striking out my defense are under challenge. Two orders. Suit for eviction of tenant. Now, Lord.
7-2. Strike on, nothing is there, Mr. Banerjee.
No, Lord, I'll just not argue one point, my lord. If a
What
lordship
point?
takes the plaint, my lord, if a lordship takes the plaint, this is not a suit not under any of the grounds under section 6, what I find. My client, by way of abundant precaution or by mistake, has filed not the 7172. But my lord, if your lordship sees the point is that it was for 4 years, the period has expired, by efflux of time, I am no more a tenant. That is the case made out. Neither default nor reasonable requirement nor MOP building, rebuilding, none of the grounds. If it is not under section 6, then section 7 or 7C will not apply to my case.
You have raised that point.
This point, no. 7-1 was filed, 7-2 was filed by my client. I have not raised this point. I find today, I found the plaint, my lord, and I find this is a suit not under section 6. Any of the grounds under section 6. This is one. Secondly, in the 7-2, finding is that 1 month's default, but the court has held me to be defaulter. Although default is not a ground. Amendment হয়েছে নাকি এটা? Instruction দিয়ে আসবি? কবেকার suit এটা? কিছু আছে? এখন ground ই নেই। কেন 7 করলো আমি আজকে করতে গিয়ে দেখছি।
Why do you say that it's not a suit under the Premises Tenancy Act?
No, I say, my lord, that they have said that I'm a premises tenant. Paragraph 1, they have said I'm a premises tenant. But the grounds of eviction. And section 7, the opening words of section 7 is that on a suit filed on any of the grounds mentioned in section 6, then learn the provisions of section 717.
Mr. Banerjee, the property is situated in a municipality. So, and the agreement is not a registered agreement.
No. Monthly
Second.
tenancy.
Third is,
the first line of the plaint is that the defendant was inducted as a monthly premises tenant. That is the first line of the plaint. But then the case of not 4 years comes, which I say I'll get the protection of.
Is it not a suit under 6(1)(e)?
6(1) is the tenant.
But the tenant has given notice to quit. I am not the, I have not given any notice to quit.
Agreement itself, please kindly come to,
Notice to quit, but has failed to deliver vacant possession.
page 8, paragraph 8. Time of induction intimated and agreed to quit. So it's a notice to quit at the time of agreement.
It's an agreement only, my lord. It says
13(1)H(G) all decisions.
If I will not get the benefit of my lord Premises Tenancy Act.
It's a section 6 suit. It's a suit under section 6.
There has to be a notice, my lord, to quit. Has to be a notice to quit.
Those old line of judgments in the agreement itself.
Agreement does it.
That's their pleading, Mr. And you have also filed your section 7.
Section 7 has been filed, my lord, but my lord,
it's a suit.
It doesn't say that the agreement contains a clause that I'll quit after 4 years. It doesn't say so. They say it agreed. So that's the pleading, my lord, that I have agreed. That will, if agreement says, the clause in the agreement says that I'll vacate and quit after I give a notice or I
will be decided. So, but you have also not raised that point. On the other hand, you have filed this suit, and this is because please come to section 6(4). Section 6(4). Notice under section 6(4) is exempted in case of 6(1)(E) and F. And that's exactly their averment in paragraph 7.
Paragraph 7.
So they have brought this suit under section 6(1)(E) and F.
If the agreement, they are not saying that the agreement
that will be decided, Mr. Banerjee. But that's their plain case.
That is a plain case. In plain reading, it doesn't appear, that case has been made out that as per by agreement.
You are finding that default and reasonable requirement. There are other grounds also.
Other grounds. Notice by tenant. Notice by tenant.
The plaint I could make out. I have not seen any other document. Reading of the plaint,
it appears that 6. In my humble submission, 6(1)(E) specific case has not been made out because they have to then say that by way of agreement, tenant has given notice. That is not.
Mr. Banerjee, whether they will succeed in that ground or not is a
no, but that pleading is also not there. That the agreement is treated as a notice.
Paragraph 4.
It says agreed to.
Yes.
Period of agreement has expired.
Yes.
Agreement was subsequently expired.
Defendant agreed to occupy.
Thereafter, second agreement was executed.
Should be treated as a notice on behalf of the defendant.
Then there was
a specific pleading. That's the notice. In the agreement, you have agreed. That's the notice. Under section 6(1)(E) and F.
If
all decisions,
if it is held
13, I think G(H), I think. Because 56 Act, I'm not dealing now. Seldom I get a chance to. G or H, if you see the old decisions, you will be getting decisions on these lines.
Because what has been held in this case, my lord, default is not a ground in the suit.
Maybe.
Only
Mr. Banerjee, even if default is not a ground, you have to file section 7 to get benefit. Because pendency, you have to, even though that is not a ground, but you have to continue to pay. If there is a default, your defense struck off everything.
I'll come to my second point. What happened in this case, my lord? 7(2), court held that for 1 month, September 21, I have not paid. 1 month. And then went on to say I am a defaulter. Now I say, my lord, that 1 month to constitute default under the Premises Tenancy Act, it has to be 3 months in a calendar.
That's for passing a decree.
Yes.
But even if there is a 1 month default, you have to deposit that.
I have to deposit.
Yes, unless you deposit, that's the admitted areas. Mr. Banerjee, the default, if there is 3 months default prior to the filing of the suit is not there, no decree on the ground of default can be passed. No difficulty on that. But even if you are a defaulter for 1 month, in section 7, you have to deposit that. You cannot say, yes, it's less than 3 months, I will not deposit.
What happened, my lord, in this case, court has specifically held me to be a defaulter in section 7(2). I say, my lord, that if the court in 7(2) comes to a tentative finding that I am a defaulter, my lord, for the purpose of an eviction suit that would contemplate defaulter under section 6, which says for a period of 3 months.
No.
That is the
That is a different thing. That's for a passing of the decree. That's for passing of a decree. Because section 7 does not say in a suit instituted only on the ground of default. That does not say.
No, it says
So-
any of the grounds. And
So let us assume that the suit is not filed under on the ground of default. Let us take a hypothetical case. Suit is filed on the ground of reasonable requirement. And maybe there is 1 month default, but the suit is not filed, being conscious of that.
area.
Can you say, no, since it's not on the ground of default, I will not file 7-1, 7-2, I will not pay rent. Because there is no default.
No, when the suit is filed, I have to, my lord.
Yes.
Any of the grounds under section 6, I have to file.
You have to file. And if there is 1 month areas, section 7-1 takes care of that. Any areas of rent. Any areas, it does not say areas as contemplated under section 6-1 A or B. It does not say so. There's a
In this
distinction
case,
in
Lord, what happened, Lord, on 28th of July, 7-2 was disposed of. I was directed to pay that 1 month's rent. Now,
You have not paid that.
by the next date, 30th of August, on 30th of August, your lordship will find an endorsement that challan was prepared and filed by me.
All matters, Mr. Banerjee, you have these
No, this
challans, but you are not paying.
No, it is the same matter. My lord. This is adjourned by your lordship, my lord. The same matter.
Yes.
So, my lord, the challan was prepared, challan was passed, and my lord, it was not returned back to me. In 7C, objection, my specific case is that it could not be traced out. Summer vacation intervened, annual vacation intervened. After reopening, fresh challan had to be passed. The court passed it and accepted the money. But that was beyond 3 months. That 1 month and 2 months, not beyond that, 4-5 days beyond that period of 3 months. But my submission is, my lord, court has come to the finding that I have failed to show that I have deposited or I have taken any steps for depositing the rent within the time stipulated. That is not the
Rightly.
case here. If your lordship sees, my lord, 28th July, lordship kindly comes with the order sheet once, my lord. 28th of July is the order under 7-2.
Yes, Mr. Datta, what do you say?
And next date,
Your lordship,
30th of August, kindly see the
after 3
endorsement.
months, my lord, it was
Challan was,
passed.
he is not at fault.
Challan-
Challan was passed.
But they have never filed an application for extension of time also, your lordship.
It was
Under
accepted
7,
by court, my
so
lord.
it was not accepted. My lord,
Subsequently, the money was deposited. Court records. It was.
Prior-
7C, I said that the challan was passed. It was not returned to me. I couldn't deposit the money.
Yes.
Then it was traced, could not be traced out. I had to pass a fresh challan, which was done after the vacation. So I have approached the court for depositing the money within time. Apparently, because your lordship will find the endorsement at order number 16, 30th August.
Order number
16.
No,
30th August.
Order number 65, 65.
No,
Order
no,
number 16.
16. 14 is
Oh, yes,
7.
yes.
16. Kindly similar at the bottom. Later.
Yes.
Challan raised for rupees 407 as area rent as per order number 14 dated 28 July. Then there's a signature. So order sheet records that I have deposited
Challan
the challan
been
for
passed.
payment. Challan was passed but not given to me. I had to deposit it after the. So I have approached the court within time. It is if it is fault of the department not tracing out the challan, for that should I be penalized not for 1 month's rent?
No, Mr. Then what did you do?
Application for extension was not filed. But I went to the court.
When?
It was done on 9th of November. The court, the summer, winter, Puja vacation started, my lord. The room reopened.
Your lordship, the order was passed on 28th of July 2022. They were supposed to deposit by August 30, 2022. They give it on November 9, 2022.
Mr. Banerjee,
court
give
reopened in
me
the
the
month of
dates
November.
of those holidays. When did it start? Puja vacation.
It reopened on 5th of November. So far as the 5th or 4th of November. Closed. My lord, 3 months expired on 27th October during my lord, this vacation.
2 months.
Not 1 month. It
1 month is
extended
the
by another
first
2
one.
months. It can be extended by another 2 months.
Yes.
So total 3 months.
Yes, so
That
the
3 months
second 2
expired.
months expired on
27th of October 2022 during the vacation.
During the vacation. And court opened on,
5th of November.
5th of November, possibly 4th or
On-
5th of November.
on that date you,
No,
There's a
9th
delay
of November.
Delay of 5. That's so there's a delay of 5 days. I say, my lord, that since I have approached the court within time with the challan, it is not my fault, or it cannot be said that I have not deposited within time. Court could not find out not the challan. For fault of not the department, not he should not be
There was
penalized.
no application to that effect, your lordship.
That is the point where she is taking the only point that formal application was not filed. But the records show
Application needs to be
that
filed.
challan was passed within time.
but Mr. Banerjee, these are on facts, not placed before the learned trial judge. How can I consider that in a civil revision application?
But in the order, if you
Only one thing can
the
be done,
mistake-
Mr.
the
Banerjee.
mistake in the order. is the
One
court
thing
says-
can be done, you have to explain all these because these are the factual part, not decided.
Kindly
You
takes
can
up-
take out an application stating all these facts. If you
Well,
can
when it
prove,
takes up the impugned order, it is a detailed order, your lordship, that has been passed by the learned
Have
trial court.
failed to show
Considering
anything.
all the documents they were on record.
no dispute. From the facts, it says, if we go by the dates, there is no dispute that he's out of time. No dispute with regard to that. Because the challan was passed on 30th of August. 2 months, the additional 2 months
Right.
expires on 30th
October.
of October. And after reopening, he also made 2-3 days delay is admitting. But what Mr. Banerjee says, that he approached the department for passing of the challan. Challan was passed as it appears from the order sheet also. His case is that that challan was not returned to him. That's the factual part.
Court
If
records
that
here-
was not, it's the court's fault. So he has to make out that case.
In the
Unless
impugned
that-
order, the court has recorded on perusal of the case record, it appears that the
Mr. Banerjee,
defendant-
I can give you one. liberty.
kindly give me liberty, I'll
You
point
can
out all
take
these
out-
facts.
Take
Because-
appropriate steps in accordance with law. Because with this, I cannot.
Your lordship,
Kindly,
this order was
liberty, I'll-
in 2022. I filed my application of 7/3 in 2024. 2 years passed, your lordship. In that objection,
You do not have a very good case on merits. You want a walkover.
well, it has been done lawfully, your lordship. The detailed order, the impugned order deals with each
That
and every.
means here, one thing is there, because he approached the court diligently. 30th of August, challan
And
was
the
passed.
trial judge records in the impugned order that he has failed to substantiate his claim. He could not provide any document, your lordship.
Mistake. That is the mistake. Court says that I have failed to show any document.
Where is that?
Impugned order, my lord, order number 65, 17th December,
Second page, your lordship.
second page, third paragraph, on perusal of the case record.
Yes.
It appears that the defendant did not file any document in support of his submission, that he filed the challan immediately after passing of the order of this court dated 28th of July. These are not erroneous findings because the record itself.
Yes, this is an erroneous finding.
Hello, kindly,
Because the order sheet records that challan was passed.
hello, kindly let me read out the later portion. The defendant also failed to show that that any petition was filed by him to inform the court that the challan filed by him was missing from the office of this court. Moreover, even if the defendant had filed the challan within the time, he must
Yes, Mr.
copy of the
Banerjee,
said
that has been
challan.
recorded. You have not filed any petition.
Petition was not filed, my lord. True, but in written objection I have stated. And if once I approach the court for not making payment of the money, my lord, can it be said that I am a defaulter? Ultimately, 5 days delay. I've shown your lordship
Mr.
that
Banerjee,
ultimately.
the difficulty is now to condone. And also, the latest decision has also come.
No, it cannot be condoned. I say, my lord, that I have approached in time. I have approached in
That
time.
you have to.
So it is not a
could
case
not
of
prove.
delayed deposit.
Mr. Banerjee, on conduct, the court says you have to have filed an application saying this fact. Because Mr. Banerjee, you knew that it was out of time. You again approached. So when you again approached, you knew that the earlier you were a defaulter or you could not pay for whatever reasons. You could have filed an application.
But this, in my humble subject, this should not be treated as a default because, my lord, I have paid, deposited the challan within time, but the payment could not be made because of the
7
reasons I have
comes
stated.
into play once 7/2 order has not been complied with. He has failed to comply with the order of the 7/2. It is
Can I join? I say,
it's recorded each and every
I say
submission
the
and has
the sheet says that I have approached the court within time. If
Yeah,
30th August,
challan
the
was
noting is
passed, your lordship.
considered.
the challan was passed. After passing of the challan, it has to go to the accounts department. Stamp and seal has to be given by the accounts department. Only then he can go to the bank and submit along with the challan, your lordship. That is what the procedure is, your lordship. Only
I not pay? If the challan is given to me, why shall I hold it back? All other
For the
months
next matter.
Great.
353 is a
Matter.
4 p.m. matter, my lord. This is a leave under section 12 of the Commercial Courts Act was granted, my lord. I had paid for revocation of that leave. That application was rejected. My lord is pleased to, my lord, pass an interlocutory order there, my lord, staying the further proceeding in the suit. My lord, I'm led by Mr. Aniruddha Chatterjee in this matter, my lord. He is not available.
He is not here.
He is not here till the 26th, my lord, so I'm constrained to pray for time. My lord, the interim order is continuing till the end of this month.
Till the end of this month.
Lord.
So let it remain. Yes, call the next matter.
My lord,
358.
my lord, kindly keep it. My lord, kindly keep it on 2 p.m. tomorrow.
Which item?
358, my lord.
358. Why?
My lord, I'm led by Mr. Shatru Banerjee, my lord. My submissions are my lord, our submission has been completed.
Your Lordship, in item number 267,
Today next.
Your Lordship, item number 267 fixed at 3 p.m. I'm appealing on behalf of the petitioner.
That 3 p.m.
Yes, Lordship.
Supplementary or monthly?
This, Your Lordship.
Please wait.
Your Lord-
Yes. Yes. Call the next matter.
Item number 222.
Yes. My lord, this is an application. The defendant number 1 is the petition before lordship in a money suit under order 7 rule 11, which has been turned down by the learned trial court.
Rightly. Contest the suit. Why do you want
Because
rejection
it
of the
is
claim?
barred under the statute, under
What statute?
Securities Controls Regulations Act 1956. The case of the plaintiff is that
What is this? কি দিলেন সব ওকালতনামা
case of the plaintiff is before that, before lordship kindly.
matter record যেটা সেই I think it's that matter where the records have come. এটা দেখান তো আলাদা করলেন কি করে? Is it that records in your matter? That suit আলাদা করলেন কি করে ওই ফাইলটার সঙ্গে?
3234. No, 3234.
আগে ট্যাগ করুন ওটাকে। আগে ওটাকে ট্যাগ করুন।
As lordship takes up, I'd like to hand over the plaint with all its annexures because that will be the most relevant thing. Lordship, Lordship, the case of the plaintiff is that he trades in the shares and the defendant number 2 was his broker. Defendant number 2 is registered with defendant number 1, that is the Bombay Stock Exchange.
Serve a copy.
Lordship kindly stays the.
Why? What is the reason?
Because date copy আছে.
Let it proceed. Mentality will be also an issue. Why are you staying after that? Yes, Ashun. By the order impugned. Contest the suits. Mentality will be, nothing will happen. There also this bar will be there. Yes, call the next matter.
It is an explicit bar.
Lord, I am
Under the act.
petitioner, Lord. Lord, my application under order 18 rule 3A was rejected. Lord, in a probate proceeding, Lord, I filed an application for examining the one of the attesting witness before the executor, and that application was rejected.
Who are you?
Lord, I am the petitioner in the probate proceeding.
No, you want the executor, you want the attesting witness to adduce evidence prior to you.
Prior to me.
Where is the reasons stated? Because you have to lead first evidence, thereafter the attesting witness.
Lord, the attesting witness, aged person, Lord, the.
Where have you said so?
Lord,
Nothing you have said it.
the application is absolutely silent, Lord.
Then
Lord, kindly consider. Otherwise, Lord, in case, Lord,
by this you have delayed. It's an order of September. Your evidence could have been completed. You have delayed this application under.
Lord, kindly consider one more thing. There shall be another problem in my probate proceeding. Lord, kindly give me a chance to adduce the evidence.
You will be given a chance. It says that you wanted the attesting witness to come before you.
Before me.
It has been rejected. Your evidence has not been.
No, not my application, Lord. In case of the attesting witness expired, Lord, then there shall be another complicity in the proceeding, Lord. I have to.
You have delayed this from September 2024. It's September 2025. 1 year you have delayed. Your evidence, attesting witness evidence, everything could have been concluded by this.
Lord, in the trial court within this period, Lord, the two witnesses cannot be examined, Lord.
What are you saying?
Lord,
within 1 year, two witnesses cannot be examined.
Lord, the 1 year's matter, the order was passed to the September 2024.
September 2025 is coming. By this time, two witnesses could have been examined.
Petition file. I'm not the written objections submitted by the objector. Even he has not, the objector has also not raised any objection regarding against my application.
What is your name? Subroto Bag.
Attesting witness Subroto Bag.
Oh, Subroto Bag is the attesting witness. Where is the written objection?
Lord, the written objection, page 14. Nothing has been denied, Lord.
Yes.
No, I'm for the opposite party.
Who is for the petitioner?
I'm for the.
Yes.
Matter. I've taken out a divorce application in 2019.
There's a possibility of settlement.
But the reconciliation.
That's the order recorded.
Yes, Lordship, I have one property, a joint flat owned by me and my husband. I have a joint savings account and I have loaned certain money documented.
What is the order impugned?
Lordship, the order
No,
impugned
they have
is
essentially sought for an expeditious disposal.
expeditious disposal.
Kindly, the next date is on 22nd September. Milord,
You have
kindly-
entered appearance.
I have entered appearance. I filed my
Reconciliation done.
Lordship, reconciliation has not been done.
Let the
for all
attempt
these
be
5
made
years.
at reconciliation on the next date, and they had filed a section 151 petition. I have filed my written objection to that. That can also be taken up. Milord.
This application under Article 227 of the Constitution.
Item number 107.
Lawsuit 107 lawsuit, I have
Service taken
a defendant petitioner lawsuit.
Yes.
Plaintiff file a suit for declaration of right title interest and recovery position.
No caveat.
No caveat. Recovery of position evicting the defendant.
Yes.
Defendant contested the suit by filing written statement, specifically stating that the one of the
application for amendment rejected.
Rejected on the ground that the provided clause of the Order 6 Rule 17.
Yes, rightly.
Lossy only amendment of the typographical error instead of
show me the amendment application.
Lossy amendment application lossy page 27 lossy. It was written 2000 instead of 200. Lossy. only to that extent.
Rate of rent,
The
only the rate of rent.
lawsuit,
Where is your original written statement?
original written statement lawsuit, page 20 lawsuit.
It prima facie appears to this court.
Item number 1018.
I am for the opposite party. Mr. Shuddhasatya Banerjee appearing in this matter. I am praying for not to remain.
Why? Where is the
This is a matter, my lord. Remember that there is sale notice given by the secured creditor bank, my lord. And there is a suffering at large, my lord. 4-5 estates are suffering the secured creditors. Mr. Mitra was appearing in the last occasion, my lord. My lord, only difficulty is that.
do you want after vacation?
No, I want before vacation, my lord. My lord, only difficulty is that.
Not this week. Yes, next. For the next
Lord,
matter.
this is that matter, my lord, where they came and said that there is an OTS. They will
Yes,
put
my
an
lord.
OTS, Mr. Banerjee. My lord, rejected. My lord, rejected.
Rejected,
Hey,
it's come. They are saying it is rejected in the mentioning I saw, my lord, but it is not
My lord,
rejected
I'm
here.
handing over the official email. I'm handing over the official email.
My lord.
That has
So
come
we
on
are
14th.
using the OTS and giving, my lord.
Has come on
They have
14th.
given, my
My
lord.
lord, kindly see the official email. That is a printout of the
My lord,
WhatsApp
my lord,
letter.
WhatsApp also is there where they are sharing the no lien account, my lord.
WhatsApp is of 11th August. On 14th August,
Yes,
the
my
email,
lord.
we have rejected it. My lord, there is nothing more, and the
We are revising the OTS, my lord. Yesterday, the IOB concerned authority person was
I have
there in the
got-
meeting, my lord.
my lord, I have got the instruction right now, 5 minutes before that, because I saw that
Minutes
printout.
before, my lord, even I got the.
Both of you are making submissions at the same
My
time.
lord,
I can't follow any one of you.
I apologize. My lord, the only ground which my lord did not dismiss and vacate their order last day, because they said they'll put an OTS. They put an OTS on 11th August, on 14th August through an official email ID, from which they gave the OTS. We have rejected it, giving them in writing.
My lord,
There is nothing left. My lord, section 14 order. My lord, they have been enjoying the stay for the last 8 months. Kindly let me place it.
OTS they have rejected.
No, my lord, OTS has not been rejected yesterday. My lord, it has
Email
been-
ID.
My lord, this,
It is in-
email, can you give me a copy, please?
It has been sent to your client.
Can you show me the email ID?
It does not say rejected. Where does it say rejected?
My lord, that is she's showing the WhatsApp. This is our 11.
No, my lord, this is in the letter also. I have given the letter also.
From my mobile, my lord. This is on 14th. My lord, this is official. My lord, if my lord scrolls down, my lord would find the email ID from which they had sent it. This is the same trail mail. They have rejected it.
My lord, even we had a talk with the concerned authority. They said you make 1 CR extra, we will
Madam,
allow
you have
it.
been directed to submit an OTS proposal
Yes, my lord.
commensurate with the dues.
Yes, my lord.
Prayer has been rejected. Please go through this.
Yes, my lord. This email has not come to us, my lord.
5 minutes before I have taken instruction.
5 minutes before he has taken instruction, my lord. I am taking instruction every day, my lord. My lord.
May I, my lord, make some submission?
Yes, my lord. Mr.
That order
Banerjee is there, my lord.
My lord, I'm seriously opposing this.
Yes, Mr. Banerjee.
There is
My lord,
nothing.
we are seriously, my lord, pressing for this. My lord, I'm sure my learned friend is seriously opposing this.
Your
My lord, we had made, I tell you, lordship, my lord, we had made a proposal for my lord 14 crore.
Yes.
My lord, against that, my lord, we got a response. My lord, they requested us to, my lord, enhance, my lord, this offer, my lord, a little more.
Yes.
My lord, simultaneously with this request, my lord, they sent us, my lord, an account number, a only an account number for us to put in the money. My lord, we have, my lord, enhanced the offer is for them, my lord, to say yes, which, my lord, we have, my lord, a confidential information that, my lord, this is going to happen. And, my lord, there is no communication. My lord will kindly record this on instruction, my lord, I'm submitting from their end, which has reached us, saying that, my lord, our offer of 14 crore has been turned down. My lord, there is a request, my lord, to enhance this, and that's it.
Mr. Banerjee, please
My
give
lord,
me.
they have not given any enhanced
Sir,
offer.
please show me that you have
The kindly see, my lord, now, my lord, the version is changed.
received.
Yes, my lord.
Show it
Oh
to
my
us.
lord, I
এই
haven't
দেখুন
received.
Please look at that.
এই যে আপনার ইমেল আইডি থেকে এসছে সঙ্গীতা মুখার্জি, এই যে এটা হচ্ছে যেটা আছে
My lord, let us not waste my lord's time, my lord, will come back tomorrow, my lord.
Yes,
Let
no.
us not waste my lord's time on this. My lord, we will have a talk, my lord, I will, my lord, personally speak with my learned friend,
My
we'll
lord,
come back tomorrow.
to spam or whatever, my lord,
No, no.
I agree, my lord. But my lord,
Do you want to have
yesterday.
a copy?
Lord, I'll give her a copy right now.
Please.
Madam, let us not waste my lord's time, my lord, on this. We'll
Right.
come back tomorrow. I'll personally speak with my learned friend, my lord. There is a miscommunication. My lord, let us clear it out. My lord, we'll come back.
Copy in course
Very-
of this day,
Thank you.
I'm recording your submission. The learned advocate appearing for the, Mr. Banerjee, learned advocate appearing for the petitioner submits that,
On instruction.
on instruction submits that an OTS proposal has been, already submitted before the bank, but but the bank is yet to communicate their decision on such proposal.
They have requested us, my lord, to enhance, my lord, our offer a little more. That's, my lord, it.
কি বললাম?
My lord, he's saying this on instruction. Very well.
Yes, my lord.
And the bank has requested them to enhance their proposal. Full stop the paragraph. The learned advocate appearing for the opposite party submits that the prayer for OTS proposal has already been rejected by the bank. Full stop, Mr. Banerjee submits that no communication has been received by the petitioner till date. Full stop, the learned advocate appearing for the bank opposite party herein assures this court that the communication, that the physical copy of the document shall be handed over to the learned advocate on record of the petitioner by tomorrow. Full stop, list this matter under the same heading on Friday.
Lord, Friday,
Yes,
let it,
my lord. Yes, yes.
Friday, yes, next.
my lord, to be mentioned, my lord, kindly. My lord, kindly let it
Not
be
to
under,
be mentioned under the same heading. Yes, next.
my lord, let it be, let
Yes,
it be come out the
call
first
this
matter.
matter.
My lord, kindly let the
Grateful. Great.
matter under the special note, kindly.
Why?
My lord, otherwise it will not be,
Special urgency, sir.
my lord, kindly, you were trying to
So
bracket this or,
that I will consider where to be placed.
my lord, Friday it will be 3:30, my lord, kindly considers.
So please don't dictate the court in that.
My lord, I'm not dictating.
Where to be placed?
I'm extremely,
Where, at what
I-
time?
my lord, I
It's already
apologize.
5:05.
My lord, I'm apologizing, my lord. My lord, kindly,
Dictate,
I
every
apologize.
time you are dictating this matter to be placed
No,
here
no, no,
in
I-
position to be taken up at that point of
No, no.
time.
My lord, I'm extremely sorry. My lord,
Junior member of the bar,
I apologize, my lord, I tender my apologies.
dictate the court with when the matter will be taken up,
My lord,
where it is to be placed, at what time it will be taken up.
Lord, I apologize, my lord, I tender my apologies.
Sir,
Kindly,
consider the urgency of all others.
Lord, I'm extremely sorry, my lord.
I think thrice or fourth this matter was taken up.
Yes, my lord.
Other matters have not been taken up.
My
You mean to say that those other matters are not urgent?
No, my lord, I'm very grateful for the opportunity, my lord. I'm extremely sorry. My lord.
Every day you are saying, coming, mention. Today in the morning also you have mentioned. It has been taken up today.
Yes, my lord.
Till now, this is you could not show any physical copy that the proposal has been rejected.
My lord,
I'm giving you time, then that date, 2 p.m.
I'm
It
sorry.
will be 3:30. 3:30, it's up to you whether you will make 3:30 or not.
Grateful, your lordship.
And I apologize, my lord. Kindly would not kindly
Please
take me otherwise.
Quote in that.
Well, I was not trying to take.
Thank you.
I'm
Yes.
extremely sorry.
Lordship, I am appearing here the opposite party, Lordship.
Pass over. Next. Call the next matter.
Number 1263.
One two six three
For the
appeared
opposite party.
for petitioner led by Mr. Probal Mukherjee, my lord.
Yes.
Lord.
Where is Mr. Mukherjee?
My lord,
I'm being led by Mr. Rahul Kormukar in this matter of.
my lord, kindly make him not to this.
The strategy tomorrow. It will.
My lord, only one thing, my lord, tomorrow, my lord, I won't be coming, my lord. I was,
Need to come your junior.
my lord, only item, CO number civil revision application due to appear tomorrow as new motion. kindly, my lord, request, hey, today, কি আসছো? বলে দিয়ে যশোর করে দিই,